ಹೇಳಿದೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ. You first comply of fiction ಬರುತ್ತೆ. 438 ಗೆ ಬಹಳ ಪ್ರಿಫರೆನ್ಸ್ ಕೊಡ್ತಾ ಇಲ್ಲ ನಾವು. 439 ಆಟೋಮೆಟಿಕಲಿ ಬರುತ್ತೆ. Priority it will be taken on priority. Next.
Page number 6, number 40.
Page number 39. Number 39. That time I paid for the appointment. They have filed the memo.
ಸರ್ ಅಡ್ಜರ್ಮೆಂಟ್ ಗೆ ಅಷ್ಟೇ ಇದು, ಸಬ್ಮಿಷನ್ ಗೆ ಅಲ್ಲ ಇದು ನಾನು ಕಾಲ್ ಫಾರ್ ಮಾಡ್ತಾ ಇರೋದು. ನೀವು ಇದೆಲ್ಲ ಕತೆ ನನಗೆ ಅಡ್ಜರ್ಮೆಂಟ್ಸ್ ಒಳಗೆ ನಾವು ಇಟ್ ವಿಲ್ ಕಮ್ ಬಂದಾಗ ಹೇಳಿ. ಅಡ್ಜರ್ಮೆಂಟ್ಸ್ ನೋಡೋಣ ಬಂದಾಗ ಹೇಳಿ.
Page number 4, serial number 41 to 54.
Serial number 44. Serial number 44. Serial number 49, my lord. 2 weeks time may be granted to file a charge.
Name started is from 47. Next week as per request. Hele sir.
Serial number 49, my lord. 2 weeks may be granted to file a charge sheet.
2 weeks as per request.
Serial number 55 to 64.
2 weeks as per request.
Lord, serial number 64, my lord. 2 weeks kindly, my lord. 64.
2 weeks as per request.
Page number 6, 65 to 70.
Lord, serial number 68, Lord, kindly, 1 week time. 68.
68 1 week, 67 2 weeks. Hindi 2 weeks, 14 to super. Sir, second time list ಕರಿತಾ ಇದೀವಿ. serial number 15 ಇನ್ನ ಬಂದಿಲ್ಲ, wait ಮಾಡಿ. 13. Second time this is being posted, sir. Serial number 13, 2 weeks.
Number 14.
Huh.
This year.
Huh.
This is answer of investigation. Correct, the document you are bound to produce. ಇಲ್ಲಿ ಕೊಡೋ ಮೆಮೊ ಹಚ್ಚಿ ಕೊಡ್ಬೇಕು ನೀವು. ಅಲ್ಲಿ ಅವ್ರ ಕಾಪಿ ಶುರು ಮಾಡಿ.
My lord, serial number 2, my lord.
ಸರ್ ನೋಡ್ತಾ ಇದ್ದೀನಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿತ್ತು, ನೋಡೋಕರೆ ಅವಕಾಶ ಕೊಡ್ತೀರಾ? ಇಲ್ಲ. ಹ ನೀವ್ ಏನ್ ಹಾಕಿದಿರಿ ನೋಡ್ತೀನಿ, ಅದು ಇತ್ತಂದ್ರೆ ಕನ್ವಿನ್ಸ್ ಆದ್ರೆ ನಿಮ್ಗೆ ಕೇಳೋದನೇ ಇಲ್ಲ. Correct, okay. What is the crime number of Vishwanathpura police station wherein this matter is transferred? ಅದು ಇಲ್ಲದೆ ಬೇ ಕೊಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. ಕ್ರೈಮ್ ನಂಬರ್ ನೀವ್ ಹೇಳ್ಬೇಕು, ನಾವ್ ಹೇಳಕ್ ಆಗಲ್ಲ. ನಮ್ ಕೆಲಸ ಅಲ್ಲ, ನಿಮ್ ಕೆಲಸ. ನನಗ್ ಗೊತ್ತಿಲ್ಲ, ಇಲ್ಲಿ ಏನು ಇಲ್ಲ. ಅದು ಇಲ್ಲ, ಹ್ಯಾವ್ ಟು ಕಂಪ್ಲೈಂಟ್. ಎಲ್ಲಿದ್ದೀರಿ ಸರ್? 111 ಅದು ತಿರುಮಲ್ ಶೆಟ್ಟಿ ಹಳ್ಳಿ ಕ್ರೈಮ್ ನಂಬರ್. ವೆನ್ ಇಟ್ ಈಸ್ ಟ್ರಾನ್ಸ್ಫರ್ಡ್ ಟು ವಿಶ್ವನಾಥ್ಪುರ, ಅಲ್ಲಿ ಫ್ರೆಶ್ ಕ್ರೈಮ್ ನಂಬರ್ ರಿಜಿಸ್ಟರ್ ಆಗುತ್ತೆ. ಆ ಕ್ರೈಮ್ ನಂಬರ್ ಯಾವ್ದು? ಯಾಕಂದ್ರೆ ನೀವು ವಿಶ್ವನಾಥ್ಪುರ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಕ್ರೈಮ್ ನಂಬರ್ ಬೇರೆ ಕೇಳ್ತಾ ಇದ್ದೀರಿ. ವಿಚ್ ಇಸ್ ದಟ್ ಕ್ರೈಮ್ ನಂಬರ್? ಸ್ವಾಮಿ, ನಾನು ಹೇಳಿದ ಅರ್ಥನ ಸರ್. ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಒಂದ್ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಇನ್ನೊಂದು ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಟ್ರಾನ್ಸ್ಫರ್ ಆಯ್ತಂದ್ರೆ ಆಟೋಮೆಟಿಕ್ಲಿ ಕ್ರೈಮ್ ನಂಬರ್ ಚೇಂಜ್ ಆಗುತ್ತೆ. ಆ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಕ್ರೈಮ್ ನಂಬರ್ ರಿಜಿಸ್ಟರ್ ಆಗುತ್ತೆ. ಅದು ಅರ್ಥ ಆಯ್ತಾ ನಿಮಗೆ? ಒಂದು ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಇಂದ ಇನ್ನೊಂದು ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ಗೆ ಕ್ರೈಮ್ ಚೇಂಜ್ ಆಯ್ತಂದ್ರೆ ಹಳಿ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಕ್ರೈಮ್ ಒಳಗೆ ಆ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಕ್ರೈಮ್ ರೌಂಡ್ ಅಪ್ ಆಗುತ್ತೆ, ಇಲ್ಲಿ ಫ್ರೆಶ್ ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಆಗುತ್ತೆ. ವಾಟ್ ಈಸ್ ದಟ್ ಕ್ರೈಮ್ ನಂಬರ್? ಗೊತ್ತಿಲ್ಲ ನಿಮಗೆ? ಸರ್ಟೇನ್ ಮಾಡ್ಕೊಳ್ಳಿ, ನಿಮ್ ಕೆಲಸ ಸರ್, ಅದು ನಮ್ ಕೆಲಸ ಅಲ್ಲ. ಯಾಕಂದ್ರೆ ಐ ಕೆನಾಟ್ ಗ್ರಾಂಟ್ ಇವೇಗ ಇನ್ ವಿಶ್ವನಾಥ್ಪುರ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಅಫೆನ್ಸ್ ಸೋನ್ಸು ಅಂತ ಕೊಡಕ್ ಬರಲ್ಲ. 1 week. ಏನ್ರಿ? ಮತ್ತೊಂದು ಚೇಂಜ್ ಮಾಡಿ ಕೊಡಿ. ನೋ ನೋ ಸರ್, ಯಾಕಂದ್ರೆ ಅದಕ್ಕೆ ಅದಕ್ಕೊಂದು ಕಾರಣ ಇದೆ. ಕ್ರೊನಾಲಜಿಕಲ್ ಏಕ್ ಬರ್ಬೇಕಂತ ಅದನ್ನ ನೀವು ಓವರ್ ಮಾಡ್ರಿ ನಾವ್ ಎದಕ್ ಮಾಡ್ಬೇಕು ಅನ್ನೋದನ್ನ then you do it. No sir, ಅಲ್ಲಿದು 1 week ಅಲ್ಲಿದು ಒಂದ್ ಪೇಜ್ ಹಿಂದೆ ಮುಂದೆ ಮಾಡ್ಲಿಕ್ಕೂ ನೀವು ಅದನ್ನ ಓವರ್ ಮಾಡಂತೀರ ಮಾಡಿ ಅದನ್ನ
My lord, serial number 2, my lord.
ಹೋಗಿದೆ ಸೀರಿಯಲ್ ನಂಬರ್ 1 week ಹೋಗಿದೆ ಸರ್.
My lord, one clarification was required, my lord. One small
ಸರ್ I'll come next. Rejected, sir. If it is not complied today, it will be dismissed.
I'll do it.
If you don't comply, it will be dismissed today.
I'll do it.
ಅಷ್ಟೇ ನಿಮಗೂ ಅಷ್ಟೇ ಇವತ್ತು ಕಂಪ್ಲೈ ಆಗಲಿ ಅಂದ್ರೆ ಹೊಸಾಗುತ್ತೆ. Yes, what is you want to submit, sir?
my lord, there is one small clarification was supposed to be required, my lord.
Clarification ಇಲ್ಲ, ಇದು compliance ಇದೆ.
Compliance ಇದೆ ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ officers has mentioned there is a difference between charge sheet and judgment order copy. That is the offenses mentioned in the charge sheet. It is 380 under 380 section 380 457 read with 34, my lord. But in the this one judgment, it is mentioned as section 395. Your lordship may be pleased to turn page 18, my lord. 18, it is clearly mentioned in the para 10, my lord, in the page 18. The trial court had framed charges under section 395, my lord. In the page 18, my lord. In the para 10.
Serial number. The official raised objection stating that the crime referred in FIR and the relief claim does not tally with each other. But on perusing the records, it is evident that in Kalambala PS crime number 272 of 2015, the FIR is lodged for the offences punishment under section 457 and 380 of IPC. However, the records further disclose that after investigation, charge sheet has been submitted by the police and by the investigating agency in the said crime itself for the offence punishable under section 395 IPC, this of 457 and 380 of IPC. Under these circumstances, office objections does not survive for consideration. Further, the records also disclose that the charge is in section 397 IPC. Under these circumstances, office objections did not survive for consideration and accordingly stands rejected. Learned HCGP is directed to take notice for respondent state. Please the matter for objection statement after 1 week.
Your Lordship, serial number 4, Your
Much
Lordship.
obliged, my lord.
ಹೇಳಿ
Your Lordship, I'll comply with the office objections.
1 week ಕೊಟ್ಟಿಗೆ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್.
I'll
Next,
comply, Your Lordship, the matter is of.
ಯಾವಾಗರೆ ಕಂಪ್ಲೈ ಮಾಡ್ರಿ 1 week ಕೊಟ್ಟಿದ್ದೀನಿ ಅಷ್ಟೇ.
Yes, sir. Much.
ಏನಾಯ್ತು ಏನಾಯ್ತ್ರಿ ಅದಕ್ಕೆ? ಯುವರ್ ಪೆಟಿಷನರ್ ಕರೆಕ್ಟ್, ಮುಂದೇನು ಹೇಳಿ. ಹ ವಕಾಲತ್ ಯಾರ್ದಿರ್ತದೆ ಅವ್ರದ್ದು ಬರುತ್ತೆ ಅಷ್ಟೇ. ವಕಾಲತ್ ಅವ್ರತಿದ್ರೆ ಅವ್ರದ್ದೇ ಬರುತ್ತೆ, ನಾವೇನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಮೆಮೋ ಆಫ್ ಅಫಿರೆನ್ಸ್ ನಾಗೇಶ್ವರ್ ಹೆಸರೊಳಗಿದೆ. ಮೆಮೋ ಆಫ್ ಅಫಿರೆನ್ಸ್ ನಾಗೇಶ್ವರ್ ಹೆಸರಿನಲ್ಲಿದೆ, ಅದಕ್ಕೆ ಅವ್ರ ಹೆಸರು ಬಂದಿದೆ ನಾಗೇಶ್ವರ್. ಮನು ಅರ್ಥ ಬಂದ್ ಮತ್ತೆ ಮನು ಅವ್ರದ್ದು ಹೆಸರಿದೆ, ಮತ್ತೆ ಇಬ್ಬರ ಹೆಸರು ಮೆಮೋ ಆಫ್ ಅಫಿರೆನ್ಸ್ ಇದೆ. serial number 20. The office is directed to mention the name of say the 11th council Nagaya who is in the southwest. ಮುಂದೆ ಹೋಗುತ್ತೆ. It is not compliance ಗಿಂತ ಇಲ್ಲವೇ ಇಲ್ಲ ಇವತ್ತು. ಕೊಟ್ಟಿದ್ರು ಅದಕ್ಕೆ ಕಂಪ್ಲೈನ್ಸ್ ಹಾಕಿಲ್ಲ ಸರ್ ಅವರು. PF ಅಂತ ಹೇಳಿ ಪೋಸ್ಟೇ ಮಾಡ್ಲಿಲ್ಲ ಅವರು. ನೋಟಿಸ್ಗೆ ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಕೊಡಕ್ ಮಾಡಿದ್ರೆ R2 ಒಂದು ನೋಟಿಸ್ ಕೊಡ್ತೀವಿ ನಾವು ಅಷ್ಟೇ. ಇಶ್ಯೂ ಮಾಡ್ತೀವಿ.
Number 35 minutes, right price. 35.
ಅಯ್ಯೋ issue notice to the respondent. Meanwhile, the learned counsel is also directed to furnish the copy on the name of the penal advocate. Is the matter next week. Serial number 36. That is same order. 35, 36. What? ಇದೇನು ಸಿವಿಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್? Who are you to object? ಕೇಳಿಲ್ಲ ಕೇಳಿ ಹೇಳ್ರಿ. What is your problem, sir? ಅವ್ರ ಏನೋ ಡಾಕ್ಯುಮೆಂಟ್ ಈ ಕ್ವಶನ್ ಆಫ್ ಓನ್ಲಿ ಬೇಲ್ ಇಸ್ ಕನ್ಸರ್ನ್. ಬೇಲಿಗೆ ಅವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ಅದಕ್ಕೆ ನಾನು ಕೌಂಟರ್ ಹಾಕ್ತೀನಿ. ಏನಿದೆ ಎನ್ನೆ ಈಸ್ ಇಟ್ ದಿ ಮ್ಯಾಟರ್ ಇಸ್ ಟು ಬಿ ಡ್ರ್ಯಾಗ್ಡ್ ಆಸ್ ಇನ್ ಕೇಸ್ ಆಫ್ ಎ ಸಿವಿಲ್ ಲಿಟಿಗೇಷನ್? ಮತ್ತೆ ಆಯ್ತು, ಅಬ್ಜೆಕ್ಟ್ ಏನದಕ್ಕೆ? ನೋ ಸರ್, ರಿಜೆಕ್ಟೆಡ್. ಅಡಿಷನಲ್ ಅಬ್ಜೆಕ್ಷನ್ ಅವನ್ನೆಲ್ಲ ಎಂಟರ್ಟೈನ್ ಮಾಡಲ್ಲ ನಾನು. See, I have given you an opportunity. He has produced certain documents. Other ಮೇಲೆ whether the documents are relevant or not, whether the grounds urged by the other side for cancellation of the bail are genuine or not, whether there is any violation, whether it is falls within the framework of the guidelines laid down by the apex court, these are the only things to be considered. ಅದನ್ನ ಬಿಟ್ಟು ಉಳ್ಕಿದ ಕಥೆ ಎಲ್ಲ ನಾವು ಅದಕ್ಕೆ ನೀವು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕೋದು, ಮತ್ತ ಅವ್ರ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕ್ತಾರ, ಮತ್ ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಅಬ್ಜೆಕ್ಷನ್. ನೋ ಸರ್, ಏನ್ ನಿಮ್ಗೆ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಡೇಟ್ ಕೊಡೋಲ್ಲ. ಇದಕ್ಕೆ ಅಡಿಷನಲ್ ಹಿಯರಿಂಗ್ ಡೇಟ್ ಕೇಳಿದ್ರೆ ಕೊಡ್ತೀನಿ, ಅಬ್ಜೆಕ್ಷನ್ ಅಂದ್ರೆ ರಿಜೆಕ್ಟೆಡ್. ಇಲ್ಲದ ಕಥೆ ಹೇಳಕ್ ಹೋಗ್ಬೇಡ್ರಿ ಕೋರ್ಟಿಗೆ ವಕೀಲ್ರು. ಬಿ ಫೇರ್. ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ರೆ ನಿಮಗೆ ಏನ್ ಕಷ್ಟ ಸ್ವಾಮಿ? ಹೌದು, ಜನ ಚೆಕ್ ಮಾಡ್ಕೊಡ್ರಿ, ನಿಮ್ ಪಕ್ಷನ ಕೇಳ್ರಿ, ಹೋಗೋದೋಗುತ್ತೆ. ಅದಕ್ಕೆ ಮತ್ತೊಂದು ಅಬ್ಜೆಕ್ಷನ್. ನಥಿಂಗ್. ನೀವು ಕ್ಲಾರಿಫೈ ಮಾಡಕ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬೇಕಾಗಿಲ್ಲ ವಕೀಲ್ರೆ. ಯು ವಿಲ್ ಗೆಟ್ ಎ ರೈಟ್ ಆಫ್ ಆಡಿಯನ್ಸ್ ಅಲ್ಲ ಮತ್ತೆ. One nimsha, one nimsha. There are certain objections on your memo of production of documents also. Copy serve ಆಗಿದ್ದಾರೆ. Copy serve ಆಗಿದೆ. The learned council for the learned HCGP and learned council for are to submit that the copies of the additional documents were received by them. Hence, office objections does not survive for consideration regarding production of documents. Yes, ನೀವು ಹೇಳಿ, let him argue on some other day. He can argue. Sir, ನಿಮಗೆ opportunity ಕೊಡ್ತಾ ಇದ್ದೀನಿ. I am giving you an opportunity. ನಿಮ್ಗೆ accommodate ಮಾಡ್ತಾ ಇದ್ದೀನಿ. Our argument ಗೂ ನಿಮ್ಮ projection ಅಂದ್ರೆ that is the last. Then I am not going to hear you also. Let him argue. ನಿಮ್ಗೆ opportunity deny ಮಾಡಿದ್ರೆ you can raise objection. ನಿಮ್ಗೆ ಒಂದು ಡೇಟ್ ಕೊಡ್ತೀನಿ, ಅವತ್ತು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ರಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. Yes, I didn't follow you. If you want to argue today, I have no objection. I'll hear you. For him, I'll give some other date because he is not prepared. In view of your production of documents, he is not prepared. I'll accommodate him. But since you assert that you have come on from long way, I'll accommodate you. You can argue the matter. Sir, ನಿಮ್ಗೆ ಹೇಳಿದ ಅರ್ಥ ಆಯ್ತಂದ್ರ ಅರ್ಥ. ನೆಕ್ಸ್ಟ್ ಯಾಕೆ ಸರ್ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಸರ್? ನಥಿಂಗ್ ಸರ್. ಲೆಟ್ ಹಿಮ್ ಆರ್ಗ್ಯೂ. ಹೇಳಿ ಸರ್, ಯು ಕ್ಯಾನ್ ಆರ್ಗ್ಯೂ.
This particular matter is comment number 2. Essentially, 26 of August 2011. That question to the boundary of 60.
Sir, we are concerned. Now you are coming here for cancellation of the bail. So when you are coming for cancellation of the bail, very limited scope is there. The apex court has already laid down a law that the high court or the apex court should be very slow when the trial court has exercised the discretion of granting the bail. If there is any breach of conditions that you can highlight, absolutely no issue.
Order dated 27 September 2018. Petition 762 2018 was based on fraud committed on civil and black mass.
Which order you are challenging? A high court order?
First, the order is
Let it be. The bail was granted by the high court or the trial court?
session.
Then why don't you approach the sessions court for cancellation of the bail?
We made our case the solid basis. I mean, first case was and we was
You are arguing that order is manipulated.
sir,
See, think of it.
because vote was manipulated.
Huh?
Vote
Court is manipulated.
So this is an obligation to submit the factual report. I think there was nothing that was. I'll prove that. Finally, see document number 2, my lord. I complained. Written complaint to the SHO. Document 2. Very good. application to register first information report. The document was the memo man. Document 2, the memo also, application to register first information report against my father for intention. That is the second one. My father has been behaving in an unethical way for years. He would create disputes over the smallest of things. This would result in altercation. My dad would end up beating my mom, threatening and beating my mom. For instance, he had mandated that as soon as he came back from office, 2 glasses of water ought to be kept on the dining table. Okay. This shows the altercation, regular altercation between the parties. Due to my father's inappropriate behavior, me and my sister had implored my mother to divorce or take action against my dad several times, but she always refused. In the presence of just my sister, she revealed that she wouldn't take any action until we are both well settled. And now on the afternoon of 26 August, my mother passed away when she was killed by my father from a flat on the 16th floor. At that time, this was purported to be an accident. On that fateful day, my paternal family utilized the fact that I was emotionally broken and they pressurized me to provide statements which were not true and were according to them. We are both all still students and were told now that our mom was gone. No one else except your father who take care of us. Tumhara aur kaun hai? Now that my mother's last rites were completed, they are out of their clutches and they cannot enforce undue influence and pressure. Right now, I'm feeling much more confident to speak the truth before the authorities and make a request to people that is against the father. Open now. No FIR has been registered. Now, para number 5, sir. On the afternoon, I was reading a book in my room where I heard my parents fighting. This was a routine. After a while of fighting, I heard my dad shouting, "मैं तुझे जान से मार दूंगा." तेरी इतनी हिम्मत की तूने मुझ पे हाथ उठाया, to which my mom replied, पूरी जिंदगी पिटाई ही खाती आ रही हूँ, एक दिन तो मार सकती आदमी. Then I started moving outside from to see what's going on. I saw my dad standing in the balcony. He lifted my mom up by her legs and stripped her over. I rushed to the balcony. When he saw me, he joined his hands and begged, "मैंने कुछ नहीं किया, मैंने कुछ नहीं किया, मैंने कुछ नहीं किया." After I came down, I saw this is the FIR. And the last para, therefore, I make a request before the competent authority investigating officer to the application. And what FIR being registered
Your colleague is there.
11-9 ಗಂಟೆಗೆ
So simple thing. Initially, a complaint, the FIR is registered under section 306. Correct. So now you are alleging that it is not a 306, it is a cold-blooded murder.
That makes the allegations. What is submitted in written complaint? What they have been written in this case? Where did it come?
Again, the FIR initially, it is simply registered, asserted that the accused the respondent number 2 herein has abated the deceased to commit suicide. All along, he pestered her, he ill-treated her, humiliated her, which ultimately resulted in she jumping from the balcony and committing suicide. That was the FIR initially registered. Subsequently, 1 month later, you lodged a complaint.
Only 13 days later, my lord. When the rights, the last rights of the deceased.
Whatever it may be, the FIR is registered on 26/8 and on 11/9 you lodged a complaint of murder. See, please restrict your arguments. See, it may be basic, all these are to be considered initial. Now, see, now you are making a grounds for cancellation, restrict to them.
Sir,
That's all.
this FIR would have been, section 302. Then what would be the result of the bail application, sir? If my lordship may I read the para number 8 of the bail order application, sir? The order of the application, sir. Para number 8, sir. The reason, sir, at page number 49 of the bail application, sir. Page number 49, para number 8, sir. How, this is point number 1, sir, para number 8. However, even if it is accepted that there is a prima facie case made out against the petitioner for the alleged offense, the said offense is not punishable with death or imprisonment. This is the reason for life. Even though it is not non-variable and extensive driver of the scope, there is absolutely no material forthcoming from the prosecution. Prosecution and the value and the obligation. So for the case. My lordship, kindly consider this on the very next day, 12th of September 2015, when I, on the copy of the FIR, I immediately moved and move an application before the Commissioner of Police. What I had been stated, that I have been written, nothing is there now. Document number 2. The memo, sir, investigation, sir. Are you under obligation? And he uses the case jack and it shows the complex testimony of these reasons. Oh, it was taken. So,
So I'll make it very clear. Even if a IO commits a blunder mistake, let us accept that IO is sailing with you. Let us accept, even if he commits a blunder, it does not prevent you from challenging the same before the competent court.
Please. When the court asks for case diary, sir, you is not an ID on this.
Sir, we're not concerned about case diaries and other things. Please restrict your argument. You are traversing beyond the scope of the court. See,
He had an obligation.
let us accept. Let us accept that IO does not produce the case diary. It is for the concerned court. Concerned court should have insisted. That doesn't mean that he has not placed the case diaries. Concerned court is misled or manipulated. No, it is the duty of the concerned court to insist, or the concerned court can pass remarks and appropriate orders. That is a different aspect. That cannot be considered here. That the case diary is not produced, that it amounts to manipulation. No. Yes.
The fashion is correct. The fashion is not proper. We will do the courts.
Yes.
Then, how to learn courts? They can do the proper judgment.
Sir, I'm not here to give regarding how the court can render a proper judgment. Here only whether bail is to be cancelled or not. On merits, I'm not supposed to do anything in this petition. Only whether if you have made out a case that they have misled the court while obtaining the bail, or they have violated the basic conditions imposed by the court, yes, you are there. See, you just enlighten the court to that extent, matter ends there. Instead of that, you are arguing on merits of the case. We are not concerned at this juncture.
Question of a material fact. And misleading is sense. Very simple, sir. It's a question of the fact.
Yes.
The investigating officer did not produce, or did not watch. It's another obligation. Just
Sir, please, sir, he may be under obligation. That is not a criteria, sir. Even if he rejects, please bear it in mind that even if IO doesn't register it under proper provisions of law, that is not the end of the case.
Investigation on 12th of September 2018. You recorded the confession. Have you recorded the confession?
Sir, you are an advocate. See, please understand what is the value attached to a confession statement.
Zero value, sir.
Then,
Very simple.
Then-
Zero value. I'm not.
then you cannot highlight regarding confession. What you can highlight regarding other material collected in this regard or statement of witnesses,
The second argument, sir.
and even otherwise, you are at liberty to challenge the charge sheet by filing objection statement.
Charge sheet has been filed under section 302.
Then
Charge sheet has been filed
on the basis of your subsequent complaint.
Yes, sir. For the investigation. Though that complaint was filed with it is enough. To the bill of it.
So one thing is certain. Subsequently, IO has submitted a charge sheet under section 302 only.
When I need in two sentences. When we move the application bill cancellation, since the section 302, which is doing offense, the bill should be cancelled. That was the first argument. Secondly, sir,
So according to you, bail is not granted for the offense under section 302. Bail is granted in respect of the offense under 306. So he cannot entitle for a bail for the offense under section 302. This is your first ground. Second, okay.
question is, when in order to be the week of January 2019, we cancel application of the single citation. Single amount. There was no reason. My best, case test upon these state from the patient.
See, anyhow, if you want to rely the citation along with memo, you can rely and the court will consider those citations.
Number 16 of this. Listed on this. State of Andhra Pradesh and Another versus East Region. Submission is yes. Number 19 parameter. By fraud is meant an intention to deceive, whether it is from any expectation of advantage to the party himself or from using goods. There is a material. The special fraud involves two elements: seek an injury to the person deceived. A fraud is an act of deliberate deception with the design of securing something by taking unfair advantage of another. I'm trying to convince my lordship that the foreign number two and does with the ideal or the authority for this order, the deceiving humble submissions may and may be allowed once other lies last time. Yes, ma'am. Humble submissions. The very order passed the basis of the FIR register of 11. The incidents happened on 26th of August. 27, we got the body to take the Buddha within place. Friends, or tried, I'm not saying or this other application can be 12th of September, 15th of September. But particular. Students.
There cannot be two FIRs in a single crime.
No,
There cannot be two FIRs. Only thing is, in first FIR, certain offenses are quoted. If IO courts, the request the court seeking inclusion of additional the offenses, that court can permit it.
Additional offenses is different thing, sir. I quoted specifically that my father killed my mother. Should have been registered as section 362, but the question is not that's what I like. Sir, there was no earlier FIR, my lord. There is no earlier FIR. This is the first. That is 251. How this fraud committed upon the court and thus at this trying to convince the lord. In my, I just want the
You need not read it. You can highlight the concerned pages or paragraphs.
Even when the another court elected the application, suggestion. The court failed to consider. The court is there. If any other passes then actually or style of the objection. Yes.
First, I want to hear 1 minute, 1 minute. First, you want either state wants to say submit anything, whether you are selling with him or you are selling with him. I'm simply asking you whether you are selling with respondent number 2 or selling with complaint the petitioner. Hashtag Karitan. Always he sells with petitioner. Yes. Now you can argue.
Date of incident was on 26/8/2018. 3:30 at 4 p.m. She fell from 16th floor of the flat. But immediately information was given. The petitioner Millard has given a complaint for an accidental fall. UDR was registered in UDR number 31/2018 on 26/8/2018. The body was shifted to mortuary. 27th Millard, a inquest was conducted. During inquest, again this complaint was examined. Millard, his sister was examined, that is daughter of his son. Deceased. Other blood relatives are also presented. They were all examined. The report was not an accident involved from. On that day, Millard, on 6/8 Millard, there was a festival in the room. They all from Punjab, Millard. They performed some puja and festival was there. They had prepared some special food. But she had gone to balcony to keep that oven. She has well learned. It was noticed. This respondent number 2 petitioner, they were all sleeping in the room. No one, she was attending for cleaning after. Like it was noticed, everyone rest.
If it was an accidental fall, why the crime was registered under section 306?
For 11 days, Millard, it was an afterthought. Incident, Millard, was on 26/8. 11/9, 15 days later, Millard, this petitioner, Millard, he has been misguided by the village to lodge a complaint. Millard, a well-prepared type complaint was presented. The police registered an FIR, Millard, 11/9/18 for offense of 306.
Yes.
Because thereafter, this accused was arrested, Millard, on the same day. Was at home, Millard, he was brought, totally into the 229, remanded to judicial custody. He had applied for bail, Millard, with the it was granted, Millard, on 57/9/2018. After securing the entire records of the investigation, which was the 306, particularly noting the fact that initial here, the allegation of all from building was an accidental fall. The bail was granted. Russian kindly see 57/9/2018 in 1/4/2019 for more than not 8 months, 7 months. 1/4/2019 and a petition was filed under section 482. By then, Millard, a charge sheet, Millard. Petition for cancellation was filed on 4/2019. Meanwhile, in National Dynasty, 27/9/2018, when the bail was granted, as soon as this accused came out of jail, Millard, another complaint was filed. Because he has been granted bail, they made an allegation, no, it is not a case of suicide, it is that he has slipped away from balcony. Therefore, I have seen it, improved version. He becomes an eyewitness. Says that I saw that my father was slipping and going away. Well, that was Again investigated, police did not add section 302 immediately. So therefore, my lord, they confirmed that this was only accidental cause, but anyhow, on the basis of their investigation. When my lord, the petition was given to commissioner, the investigation is not made, investigation officer is citing the accused. Then my lord, the investigation was shifted to another police station. Then my lord, 302 report was added. Ultimately, my lord, after the investigation, charge sheet is filed for 498A, 302 of IPC. After charge sheet was filed for 498A, 302 of IPC, the case was committed, numbered as SC number 7. Summons was issued, which was regularly appearing, we appeared. Petition for cancellation of bail was filed, and that was notified to the accused. But ultimately, after hearing all the arguments below, on 18/1/2020, the Honorable Sessions Court passed an order rejecting the application filed by the respondent petitioner hearing for cancellation of bail. There is no ground to cancel the bail. Application was already filed. The later the Rashima Kanchi in the Sessions case was committed, and it was in Sessions case. The grant bail for 302 till the consideration of a petition for cancellation of bail. After the petition for cancellation of bail for dismissed, then independently a bail application under section 302, 498A in SC 715 for 2019 was considered, and bail was granted by order dated 19/2/2020. This is an order specifically taking note of section 302. This order will not be permitted to produce the certified copy of the order. They have taken the ground.
Yes.
So in this case, Rashmi kindly the fact of rejection of cancellation of bail petition was also taken later. Thereafter, the offence of 302 498 is also taken later. Then letting of bail has been granted to considering the reasoning. The time of page 3 minute, normal court has taken note of initially for 306, for 302, and 498. But this one paragraph about that, this entire merits of the charge sheet was considered and this order was passed. Upon this order, my lord, this bond was executed or appears to take a charge. This is not done. This is the last order, the latest order. This has not been sought for cancellation. Bail granted for offence under section 498 and 302 remains it is. This has not been sought for cancellation. This order is remains. Previous order has not been this and offence of 302 bail was granted. Well, therefore, on this count alone itself, petition do not survive unless they seek for cancellation of this bail order. Moreover, not to cancel bail, some supervening circumstances exhibiting the conduct of the accused that it is not conducive for the accused to remain on bail for bail trial. This ground is not alleged. He has not violated any condition. He is regularly appearing at each and every date of hearing, and before the trial, the application is also filed. for electronic records is not given. Some of the electronic records, also an application fully filed, not that now the state may not hear you. The accused is fully cooperating. It's not dodging the matter. So, they show such allegation also. Is ready to face the trial. In the absence of allegation of misuse of liberty granted, bail cannot be cancelled. Now, noise is the law. Grant of initial stage refusal of bail is different. Once bail is granted, in order to cancel it, there must be a cogent and overwhelming circumstances demonstrating that he has misused the liberty granted. In the absence of it, bail cannot be cancelled. And merits the Lord here, National kindly. Yes, the Lord that initial FIR was UDL. After 15 days, 306. Then the Lord for 302 allegation. There is no eyewitness. No one was there. Only one witness, the petitioner here, he time to time he improves the allegation. But in the absence of any cogent and overwhelming circumstances, demonstrating that this is a cold-blooded murder, he doesn't deserve any concession. Such allegation, no such material. That's a circumstance. First version, if it is second, it is in 306. Now 302. Wavering versions, oscillating versions are being projected time to time. Interested persons. That is important that states should not sought for cancellation and bail. And there is no allegation from the prosecution or from the police concerned that this accused has misused the liberty granted. And there is no FIR against him either for threatening the witnesses or for tampering with. For the amount of this mirror, there is recent mirror, last week mirror of another. Bail cannot be cancelled merely because it cannot be treated as a disciplinary proceeding. You want to keep the accused in a disciplined manner, that purpose bail cannot be cancelled. The first edition, my lord. Kindly go to page 4, my lord. This edition, my lord, 111 November, paragraph 4, my lord. That is paragraph 19 and 20, my lord. We might strike that normally a cogent and overwhelming proofs are required to cancel bail. Ordinarily, unless a strong case based on any supervening event is made out, order granting bail ought to be lightly interpreted. Had not been the case of prosecution that the appellant had misused the liberty or had quoted as some manner policy. We are compelled to observe what cancellation of bail should be designed with extreme care and consistency. Such cancellation cannot be argued. Discipline on the part of the courts. All such cancellation of bail cannot be opposed as disciplinary proceeding against it. But in a case where bail has already been granted, setting under section 439 that is the such cases where the liberty going to be correcting the requirements of proper trial of a accused. That is the for expansion of the issue was not required. Only for one reason. This order granting bail. Mortality is and again, not this decision also take but the decision is also the other the same principle right from the law. 1978, they got this case, where the law is time to time iterating. Instead of bail at the initial stage, but once bail is granted, cannot be cancelled lightly, but barely in the absence of any cogent and overwhelming. This is the law consistent. Next decision law is the complete page 5. All the decisions will not has been taken note of. The principal has been down. Page 16, the lot, previous decision lot, 2.1 from page. 15, also relevant to both very focused and more when I speaking how for cancellation of the are then the answer comes to the patient is around yes. It's a discipline. They must grant cancel same problem, right? The distance from this should be around our mind. So small then plus the absence of the there is some substance in the life. Now, the next case is not Rollercounts case. In this case, you will play the paragraph 4 melody is very important. The child is detection of the vulnerable case at the stage. The acceleration is very important and these things, but must write off. But any art yeah, it is almost yes and but yes is regularly appearing right 2.5 years because of lockdown it has gone no function in the airport and he has been harassed and particularly not that he is not a vagabond he is a reputed engineer software engineer not he is a qualified MBA graduate not he has been employed working in multinational software project leader. Every punctually, not even one day he has missed. Not even a single day he missed that. Every day he is punctually engaged. No allegation of tampering. Now, they cannot start to be cancelled as a revenge. Because there is a now that the mindset of the petitioner is such that somehow he should be. Not for that. Let him go on. Let it. What's it there? Let the trial go on. Or it will take its own course. But cancellation is based on this kind of conjectures and surmises, particularly making allegation case that is not to do, court not considered, police not proper. These are not considered. So I frame enough.
Is now I'll pose you one question. The other technical issues are there. We consider it. You are seeking cancellation of the bail granted in 2018. Now this, according to him, Sessions Court has granted regular bail for the offence under section 302 in 2020, which is still operating. That is not sought to be cancelled. Even for technical issue, even if let us accept that your petition is allowed. Your petition is allowed. Bail granted on 27 in 18 for the offence 306 is deemed to have, let us presume that it is cancelled. What will be the consequences? Nothing. I cannot do it, sir. This is not a case to amend the petition, go on changing the petition. You have not brought to the notice of the court regarding that he was granted bail under for the offence under section 302 subsequently. I cannot say anything. It is for you to take a call. Now your bail petition on the face of the records is not maintainable. Even otherwise, because it will not serve, even if it is allowed, it will not serve any purpose. Then heard both the counsels. The learned counsel for petitioner, respond number 2, has also produced the copy of the bail order passed by the trial court, by the 55th additional, 45th additional city civil and session judge Bangalore, dated 19th February 2020 in SC 715 of 2019, wherein the present petitioner was granted a regular bail for the offence under section 302 IPC. And admittedly, the earlier bail granted for the offence under section 306 stands merged with this subsequent order dated 19th February 2020. The records, the petition further discloses that there is no prayer for cancellation of the bail dated 19th February 2020 in respect of the offence under section 302 IPC. However, the relief sought is for cancellation of the bail dated 27/9/2018 in respect of the offence under section 306 of IPC, which will not serve any purpose now. Considering these aspects, the learned counsel for petitioner submit that he may be permitted to withdraw the petition with a liberty to move a fresh petition The submission is placed on record. The petition is dismissed as withdrawn with a liberty prayed for, if he is advised to do so.
The hearing,
No, I have recorded it. I have heard both the counsels and record ಮಾಡಿದ್ದೀನಿ others. That is the reason I have recorded a detail. Otherwise, I would have simply done. After arguing the matter, he has sought for withdrawal. But I have mentioned the production of documents and other things.
whether it is appropriate to give liberty whether to give access.
We cannot deny liberty, but burden is on him to establish everything.
Very absurd.
That is
Liberty is given with the brand.
liberty are always given, but always burden will be on him only. That burden cannot be taken, it cannot be casted on you at any point. And therefore I use one, if he is advised to do so.
Petitioner is request number 3 in law. For the offense, after the charge sheet on law, the offense punishable under section 8, clause C, federal section 20, subclause B, subclause 2, subclause C, and 27, 27A, 28, and 29 of LPS Act. As per the allegation, my lord, kindly see page number 7, the FIR, the information submitted by the respondent, my lord. Page number 7. On 12/4/2022, information was received from reliable sources that one person named Om Prakash Gupta, along with another person named Pankaj Verma, are traveling for Ice Park duty on 11/4/2022 and about to reach at Bangalore at 2:45 hours on 13/4/2022 in Gorakhpur Superfast Express, train number so in coach S4, seat number 29 and 30, were carrying charas, hashish, narcotic drug in their luggage bag, and will probably get down at Yeshwanthpur Junction railway station on 13/4/2022 and hand over the contraband to Bangalore to a person named Anurag Kumar Halwa. That is a person. If the said persons are intercepted at Yeshwanthpur Junction railway station and searched, the drugs can be seized and the suspects can be apprehended. As per this information, the NCB team reached at around 1:20 hours on 13/4/2022, Yeshwanthpur railway station, Bangalore. Om Prakash Gupta and Pankaj Verma were intercepted at platform number 5 in bus train number 7 in coach S4, seat number 29 and 30. After following the procedure as per law, 3.176 kg of charas, hashish, and narcotic substance under the provision of NDA's Act 1985 was seized from the concise possession of Om Prakash Gupta and Pankaj Verma. That is case number 1 and 2. The seizure Panchanama measure was drawn on spot on 13/4/2022. Om Prakash Gupta and Pankaj Verma issued notice under section 67 of NDA's Act to appear at NCB office forthwith. On the preliminary inquiry, Om Prakash Gupta disclosed that the said charas hashish was delivered to one person named Anurag Kumar Halwai in Bangalore, and he provided his address. Accordingly, Anurag Kumar Halwai issued notice under section 67 of NDA's Act to appear at NCB office forthwith on 13/4/2022, and their statements were recorded on 13/4/2022. In their statement, they internally admitted their guilt and the role for carrying the drug, that is charas hashish, contained in bag from which 3.176 kg of charas hashish was seized on 13/4/2022 by A1 and A2, and for purchasing the above said drug by A3 from A1 and doing drug business or carrying easy money based on the voluntary statement and material evidence. Om Prakash Gupta, age 36, so my lord, they were arrested. On the basis of those two accused person, Commissioner was other than that, my lord, except the voluntary statement of accused number 1 and 2, there is absolutely no involvement of this Commissioner in whatsoever manner in the present frame, my lord. Only the reason is that, my lord, this person, this petitioner, is just a root of the other two cases. They are about to come to this person's home, Bangalore. Other than that, my lord, there is no allegation, no word, no involvement at all of this petitioner in this term. And my lord, this section 8 clause C, regulated 20 clause B, subclause 2C, my lord, no one attracted to this petition. Even section 27, 27A, 28, 28, 29, consumption or transport in my lord, whatever that attracts to other petition of the accused person. He has not at all transported, has not at all consumed, carried. He was about to receive that on the hostage. There is on the basis of the oral say of the other accused. So the investigation is completed, charges is all because of 5 years. By imposing any conditions for petition of my candidate.
There is the charge sheet copy.
I have submitted, my lord.
Charge sheet submit ಮಾಡಿ.
Same allegation. Addition. I have filed it and found addition after the direction of the same.
DP set ಕೊಡಿ. DP set. Yes, you have argued that 8C is not applicable to you.
Commented, I have not.
What section 8C reads?
No, it's similar.
prohibition of certain operations. No person shall cultivate any coca plant or gather any portion of coca plant or cultivate the opium of the cannabis plant. Produce, manufacture, process, sell, purchase, transport, arouse, use, consume, import, export, interstate, import into India, export from India, or transship any narcotic drug or psychotherapeutic substance.
The allegations of the prosecution is that the accused number 1 and 2 are intending to sell it to you. The allegation of the prosecution is that accused number 1 and 2 wanted to sell it and you are the purchaser, according to the prosecution.
Not purchasing, my lord.
Then-
Delivering to this person.
Then for what purpose? Then even let us deliver. What it says, sell, purchase, possess, everything is an offense under section 8C.
But my lord, as now,
I'm not talking about the merits of the case. Since you have not argued that, no way, none of the offenses are attracted ಅಂತ ಅಂತೀರಲ್ಲ, ಅದಕ್ಕೆ ನಾನು ಈ ಪ್ರಶ್ನೆ ಕೇಳಬೇಕಾಯ್ತು.
ಇದರಲ್ಲಿ ಏನು ಸ್ವಾಮಿ ಒಂದು ವಿಷಯ ಅದು 20 punishment for contravention in relation to cannabis and cannabis. ಇದರಲ್ಲಿ ಏನಾಗಿದೆ cannabis is not at all.
Cannabis.
This is not banned. It is not cannabis. Cannabis is not banned and hashish. Cannabis is what they call ganja of cannabis. It is entirely different source from the product. It is
Yes.
unknown sources.
Yes.
And as observed by the honorable Apex Court, by dealing with the band case, my lord, the band which is used for in some of the functions, festivals, traditionally consumed by the devotees. And those products also, my lord, the essence, ingredients used by these unknown sources, this hashish source. It is permissible. It is permitted in northern states of our country, my lord. But this cannabis or ganja, my lord, this is entirely different, my lord. Hashish or charas is nowhere from the product of cannabis. Cannabis is used for the opium or the heroin or cocaine. Nowhere connected to the ganja or the charas, this hashish.
Yes.
And that is the reason, my lord, no section is attracted to me. Still, my lord, now.
8C is not attracted, still you are asserting.
Consumption
20B is different, 20C, but 8C is not applicable. 27A is not applicable to you. Looking to their allegations, I'm not talking that they have established. I'm simply asking you, looking to their allegations.
Yeah, not at all. That's it. Consumption is a part of
27A.
consumption, my lord.
27A does not refer to consumption. Financing, harboring. 28, attempt to commit an offense. 29, abatement of and criminal conspiracy. So you still assert that 28 and 29 are also not applicable to you. Proof is different. I'm not talking about proof and other things. I'm not going to the merits case, entirely different. Considering the allegations, whether the ingredients of section 27A, 28, 29 are applicable or not. Looking to the allegations prima facie.
DHT was, my lord, it is affected also, my lord.
So 8C is only 1 year.
The general reason is that, my lord, he is just a roommate of this person. Other than that, my lord, he is a my lord.
Yes.
In the room of this person, this petitioner, my lord, His interest was given by.
27A, who you say it is not punishable with 1 year, minimum imprisonment is 10 years. ಬರುತ್ತೋ ಅಪ್ಲೈ ಆಗುತ್ತೋ ಇಲ್ಲೋ that is frequently during the course of the trial or framing charge that will have to be considered by the magistrate the concerned special court. ಬರುತ್ತಾ ಇಲ್ಲ ಸರಿ.
Any condition, he has not at all, not earlier, no prior, any condition.
Yes.
The present picture is accused number 3. There are 3 accused in the crime. All the accused are from state of UP. And on credible information received by the NCB, that is on 12/4/2022, accused number 1 and 2, they were traveling in a train.
The facts are very clear.
And they were
The 1 and 2 were intercepted. The commercial quantity of the contraband goods were recovered from custody of 1 and 2, which is alleged to be the destination to A3.
yes, about to deliver the commercial quantity of charas 3.170 kg to the present prisoner. At that time, the accused number 1 and 2 were caught. And during the course of investigation, the NCB recorded the voluntary statement of accused number 1 and 2. And based on the voluntary statement of so, during the course of investigation, the process of identity, 2 independent witnesses have been examined by the respondent. Loss of identity, the other one has produced the charge sheet. In the charge sheet, your loss of identity page number 31. The first page is the page number 31. This is a independent witness on Mr. Kempegowda. His statement was recorded by the NCB under section CH-27 of the NDP.
How it is referred as voluntary statement of Kempegowda?
Yes.
He is a witness.
Yes, witness.
How can a voluntary statement of a witness treating him as an accused?
To be statement, it is not an abuse.
You are in a better position to explain.
And now we have not kindly come to page 34. There are relevant para, I may be permitted to read. Page number 30. Plus got it. One asking Om Prakash Gupta. Om Prakash Gupta is actually from one. And to whom he was going to deliver this charas. He said that he would be delivered to Aruna Kumar Halwai. It is number 3, present fiction. Residing at house number 38/1/6 of floor say Kalavaireshwara Swami Prasanna, Kaveri name, Goleshwari Nagar, Bangalore 24. And next we are lost kindly come to page 35.
That was the statement of one of the Pansa.
Yes, yes. And page number 35. Another independent witness, one Mr. Velu, was his statement was recorded under section 67 of the NDPS Act.
Again, it is voluntary statement.
The statement. Okay.
I simply just what you have put it, I just read it.
The last relevant page number 39.
Same word to word, same statement. Single word. Single word has not changed. Single word, everything, including comma, same to say.
So this witnesses who states that upon asking Om Prakash Gupta to whom you are going to this charge, he said that you will be referred to Patna for Halwai. And this petitioner is to purchase the charas, the accused number 1 and 2, and in the charge sheet we have collected the statement, bank statement. Yes, transfer the money to accused number 1 and 2.
That is the page number 21, my lord. Twenty-one to 28. This is a bank statement to show that indeed the present petitioner had purchased the charas from the accused number 1 and 2 and used to transfer the amount to the account of the accused number 1 and 2. And your lordship kindly see there is a sufficient materials to connect the present petitioner in the crime. There's close nexus with the accused number 1 and 2. And moreover, your lordship kindly see even the chemical analysis report also is part of the charge sheet. It is confirmed that the contraband charas were carried by the accused number 1 and 2. Now the punishment prescribed under the NDPS Act is minimum is 10 years and maximum is 20 years. And it's a commercial quantity. You must kindly see under section the findings in terms of 37 of the NDPS Act. Signed for granting the bail the accused under the NDPS Act as held by the honorable in the matter of Superintendent NCG versus also reported in 2001 at page number 117. And the another judgment I have already produced, and another judgment, your lordship is the latest judgment of the appellate court. The absence of non-recovery of contraband from the possession of the accused will not absolve a test is required under section 37 as 1 30. Judgment also I am using them. So just because non-recovery of contraband from the possession of the present petitioner, he cannot claim that there is no offense committed by him. Now there is a reverse honest.
Whether these principles enunciated herein will assist, will directly applicable to the case in hand. Simply I am looking to the head note, I am asking you. No, I do consider it. Because here, what has happened? He was traveling in a vehicle. Contraband was found in the vehicle. No personal search, no recovery from personal, in person. But vehicle, certain contraband was found.
The answer is different. But the offense court says, just because non-recovery of contraband from the possession of the accused will not absolve a test which is required under section 37 of the NDPS Act.
See, to attract section 37, first you will have to prove some prima facie evidence against the petitioner.
Yes.
Now in the instant case, except
You must honest. So yes,
reverse
yes,
one. See one thing, merely because you prosecuted, you cannot be a reverse onus. Provided you prima facie establish that he was in conscious possession, then reverse onus will apply, rule of reverse onus. Here, admittedly, except the earlier voluntary statement of accused number 1 and 2, who were found in possession of the banned contraband drugs, that they were supposed to deliver it to the present petitioner. Nothing is there.
and you must
Have you one mission? No. Blank statement. There may be
there was a nexus between the accused
see
one and
whether
two
bank
and
statement. So if you consider it, where to whomever he has transferred the money, do we mean to say that there is certain link? Because admittedly they are roommates. Transfer may be for various reasons. And confessional statement, whether it is admissible under NDPS Act.
the government judgment is not admissible. But you are not saying two independent witnesses have
That is
been
the-
examined under such.
See, again, that is going to be regarding confession statement given by the accused number 1 and 2. Indirectly, you want to, basing on reliance on two panchas, you want that court should accept the confession statement. Confession, when the confession statement itself is hit by section 25 of the Evidence Act, the statement of the witness is in this regard, whether he has got any relevance. When the basic confession statement is removed from the docket, whether the statement of the witnesses, the pancha witnesses that the two persons have confessed, whether it has got any relevance, because it doesn't fall within the purview of extrajudicial confession. Had they admitted the guilt before some third person by making extrajudicial confession, things would have been different. Here, that is not the case. Have you raided his house wherein he was staying? Have you raided? Did you find any contraband? Nothing was found, except the statement of A1 and A2. What is the other material at the juncture?
And statement of independent witness.
That is irrelevant.
And
Both,
we have, yes. And we have.
now you are relying bank statement.
For example, you have watched ICT. The charge sheet material. Page number 9. Page number 11. When we permitted to read the summary of investigation, paragraph 22. Paragraph 22. Got it, Pranav? In pursuance of material and documentary evidence gathered in this case, it is clearly evident that Om Prakash Gupta and Pankaj Verma were in possession of 3.170 kg hashish, which gave to be seized on 13/4/2022. With voluntary statement recorded on 13/4/2022 and 15. Om Prakash Gupta, accused number 1, himself has admitted about the procurement of seized stars purchased from one person, namely Vijay Saman, residing in Tangri Road, Beluri Bazar, district Mahendra Nagar, Nepal. As per revelation of Om Prakash Verma, Vijay Saman is a supplier of seized charas and as kingpin of this case. Om Prakash Gupta and Pankaj Verma.
One, sorry for interpretation. Whether you have prosecuted, said Vijay, who has handed over the charas to these persons?
So, you have
Right. And question of arrest is secondary. Have you prosecuted?
not prosecuted.
Why?
So, because investigation is still going on. Investigation is still going on.
You want to believe his statement that they have procured from one Vijay,
Yes,
but you
yes,
don't want to prosecute him.
Still investigation is going on, and moreover, this Vijay is from Nepal.
That is a different aspect, sir. See, there are different treaties between the two states that does not bar you to prosecute him. Isn't it?
We are in the process, we are gathering the information. And next, we will also get possession, have collaborated and confirmed the fact that the seized charas was to be delivered to Anurag Kumar Halwai in the Om Prakash Gupta Yema. Further revealed that he used to receive money from Anurag Halwai. Anurag Halwai AC. He has received money from Anurag Halwai. That Nepal or Anurag Halwai used to transfer him the required amount to one Krishna Mohan Tiwari. Krishna Tiwari. Money. Krishna Mohan Tiwari. Anurag Halwai have corroborated These facts in the respective statements dated 13/4/2022 and 15/4/2022. Om Prakash Gupta brought out the facts regarding monetary consideration to be received by them for interstate transportation of steel chana. Given the chemical analysis report issued on CHSL Hyderabad,
That was your allegation, sir. That is based on a confessional statement, everything. Money transfer, now the only ground now you are urging is money transfer. Have you produced any documents to show? You have produced the bank statement of the petitioner. Who is the beneficiary? Who is the beneficiary?
Exhibit number 192.
Where is it? Where is it?
Respect is the statement.
Where is it?
Transactions are there.
All transactions are there. Here, the name will not be mentioned. Account number will be mentioned, or the transaction ID number will be disclosed. How you are going to prove that this money is received by the accused number 192? Because your charge sheet allegations are through a mediator, Krishna Kumar. Where is that statement? This person has transferred to Krishna Kumar in turn transferred to A1 and A2.
I will put in the writing copy of this bank statement.
You have already produced it.
I have not.
So it is along with part of the charge sheet, sir. Then it is only your document. Now you cannot say that you get a. Everything is legible, sir, except the name that doesn't appear there. Some transaction ID number is there. Which account, whose account, and your charge sheet allegation itself disclose that transaction is mediated through one Krishna Kumar. Then again you will have to prove that this person has transacted to Krishna Kumar in turn transferred it to accused 192.
So this bank statement, this bank account belongs to the present
Petitioner, he has totally, according to you, he has transferred about 1,12,000 and odd. But where is that it is transferred to account of accused number 1 and 2? Certain transactions were shown. You want to say that it is credited to account of 1 and 2. Where is that? The basic material corresponding statement of accused number, bank statement of accused number 1 and 2 is not produced. The bank statement of Krishna Kumar is not produced. And you want on the basis of only confession statement. How can it be, sir? Admittedly, he did not found any, he was not in possession of contraband. Your allegation is that he was a financer, isn't it? He was a financing for the drug trafficking. Indirect, your allegation is he is the financer. That is, he is the major financer. He used to finance these persons. They used to secure it and hand over it to him. He used to dispose of it. Isn't it? Where is the material except confession? What is there? Because if you want to attract section 37, there should be confession statement inadmissible. It goes out. Then what is there? Possession, they were not found in possession. He was not found in possession. Money transactions doesn't establish anything. Then how you attract section 37?
Now, in the reverse honors.
Correct, sir. Reverse onus when?
Burden lies on the.
Merely because you make an allegation that he is a drug peddler, does it mean that he has to prove that he is not a drug peddler? No, that is not the law. Law is that he should produce some material evidence to show that he is a drug peddler. Then reverse onus shifts on him. What is there? Now accept your bald allegation because he was not found anything except the confession statement, and only on the basis of confession statement. He may be financing for various reasons. How you presume that it is for a drug trafficking only? It may be hand loan also. It may be financial assistance because they are roommates. Nothing was traced in according to your submission in the room. How you overcome this? As regards J1 and J2, I am not. Sir, now charge sheet is submitted. You cannot fill in. You are not supposed to fill up the lacunas.
When produce some materials.
But then how can you produce now? Charge sheet is already submitted. Now court, when court goes on questioning, you want to go on getting the documents. No, that is not permissible. No, sir, this is, you are at liberty to approach the concerned. Clarify it. Absolutely no problem. No, sir, at this juncture, I'm out on, because the investigation is concluded, charge sheet is submitted. On the basis of charge sheet now, we'll have to analyze the things. Even charge is required to be framed on the basis of the charge sheet. No independent material required to be considered for framing the charge, isn't it? Then as regards section number 1 and 2 is entirely different. I am not expressing anything at this juncture. But as regards the present petitioner who is arrayed as section number 3,
No, as far as the bank statement is, the transaction is concerned, I will clarify with the investigating officer.
Investigating officer should have done it well in advance, not when court poses question. You have already submitted a charge sheet. See, the fact remains is, the other side should also get an equal opportunity. The investigating officer blankly produces, dumps certain aspects in the court and says that these are the financial transactions between two persons. That is not the expectation from an investigating agency. Investigating agency should produce the relevant document to show that this particular transaction is between these two persons. A vague statement produced, entire statement copy dump madbitidare. Doesn't disclose anything. I'm sorry, sir. The petitioner, accused number 3, has filed the petition in section 439 of CRPC for enlarging him on bail in
The beneficiary name clearly mentioned in the statement of account. Money was transferred from the account of section number 1.
where is that? Accused number 1 name ಎಲ್ಲದ ತೋರಿಸ್ಬಿಡಿ ನಿಮ್ಮ ಸ್ಟೇಟ್ಮೆಂಟ್ 1 or 2.
Why? I want to.
ಅಲ್ಲಿ ಹೆಸರು ಇಲ್ಲಿ ಒಂದ್ ಹೇಳ್ತೀನಿ, ಇದ್ರಲ್ಲಿ ಹೆಸರು ತೋರ್ಸೋದಕ್ಕೆ ಹೋಗಲ್ಲ. They will transferred not by name. Name will appear only if the transfer is by Paytm or Google Pay and other things. Phone Pay. Are noro ill if you are going to transfer it to the account, it will, the account details will be referred, not the name. They are not concerned with the name. Bank statement will disclose that amount from one account to another account is transferred. Matter instead. The IO is supposed to get the information regarding that account also. He doesn't want to do it. He wants to simply rely.
I want to submit it to the office.
No, sir, this is, see, we are not concerned. See, you can, correct, sir, I'm not coming in. Sir, you have already submitted this charge sheet.
I want to discharge.
Sir, it is filed by you. Your copy is handed over by you. Now you are arguing, are you, 1 minute, I'll ask you, very serious the issue you have raised. You say that this is not the charge sheet. Can you say that this is not the document handed over by you? He is producing whatever you have handed over here to him, he is producing. If he has played something fraud, manipulated, things are different. What is the gist you have furnished to him as a copy of the prosecution? He has produced it. Now you are finding fault with it. How can it be? No, sir.
File this petition under section 439 of CRPC for enlarging him on bail.
In crime number 48/1/08/22 of NCB Bangalore Zone Unit for the offences punishment in 8C 20B subclause 2 Roman 2 subclause C 27, 27A, 28 and 29 of NDPS Act, which has culminated in submission of the charge sheet in special case number 2183 of 22 on the file of 33rd Additional City Civil and Session Judge Bar Special Judge for NDPS Act, Bangalore. The brief factual matrix leading to the case at that
Quite very detailed statement of the.
heard the learned counsel for petitioner and learned counsel appearing for respondent NCB. The respondent NCB has also submitted a detailed objection statement, which is also placed on record. The brief factual matrix leading to the case are that on the basis of credible information received by the respondent, the accused number 1 and 2 were apprehended in Yeshwanthpur railway station while they were traveling, when they were returning from by train number 22533 from Aishbagh to Yeshwanthpur Junction, traveling in S4 coach querying sheet number 29 and 30. And on interception, they were found in possession of 3.176 kg of charas, particular hashish. It is also alleged that on interrogation, the accused number 1 and 2 asserted that they are required to deliver the same to accused number 3, the present petitioner. The investigating officer secured the panchas and drawn a measure and recovered the contraband from the possession of accused number 1 and 2. Then he has also recorded the confession statement of A1 and A2 in presence of the witnesses, and on the basis of confession statement, the present petitioner was also implicated in this case. Next. Thereafter, he was also interrogated and his room or house was also raided and search was conducted, but no banned articles were found in the house. Subsequently, the investigating officer is said to have obtained certain financial transaction statement pertaining to account of the present petitioner and submitted the charge sheet against the present petitioner along with accused number 1 and 2. Next. The petitioner has then approached the learned special judge seeking regular bail, and his bail petition came to be rejected. Hence, he is before this court. Having heard the arguments and perusing the records, it is evident that no contraband was recovered from the custody of the present petitioner, and all along the allegation made against him is that the banned goods, narcotic drugs recovered from the custody of A1 and A2 were required to be delivered to present petitioner who is arraigned as accused number 3. The prosecution is completely relying on the confession statement of A1 and A2 in this regard. However, it is evident, it is settled law that the confession statement of A1 and A2 for implicating A3, that is the present petitioner, is inadmissible. The learned counsel, the learned public prosecutor, special PP, special PP, no? The learned central government pleader, standing counsel, would invite the attention of the court to the statement of the Pancha witnesses who, in presence of whom the recovery was made from the custody of accused number 1 and 2, and in whose presence the interrogation was said to have been effected, wherein they have stated that both the accused number 1 and 2 confessed that they are required to deliver the banned drugs to accused number 3, that is the present petitioner. But on perusal of these statements, it is evident that they are titled as voluntary statement but not statement. Question of Panchas giving voluntary statement does not arise at all. Even apart from, even otherwise, when the confession statement itself is inadmissible, the relevance of Pancha witnesses regarding the statement of Pancha witnesses regarding confession statement given by accused number 1 and 2 doesn't have any implication. Next. The other contention raised by the prosecution is regarding the bank statement of accused number, the present petitioner, wherein it is asserted that certain financial transactions have effected between the present petitioner and he has transferred certain amounts to petitioner, the accused number 1 and 2. But this bank statement does not disclose that the amount was transferred to the account of A3, that is the present petitioner, and it simply disclosed the certain transactions. On the contrary, in the charge sheet, it is specifically alleged that amount was transferred through a mediator by name Krishna Kumar, and the bank statement of said Krishna Kumar or the bank statement of the present petitioners were not placed on record by the
His statement was recorded. Yes, not produced that statement of Kushtamon.
Krishna Kumar.
Yes, yes. Statement was recorded.
Hinbantiram.
But he has
The
not
bank
produced the
statements
statement
were
of
not
Kushtamon.
placed. on
I'm
record.
talking about bank statement, not statement. Oral statement doesn't have much relevance when there is a documentary evidence is available. And under section 91 of the Evidence Act, documentary evidence will prevail over the oral evidence. When there is a documentary evidence, oral evidence cannot be relied.
The bank statements were not placed on record.
Bank statements pertaining to accused 1 and 2 or Krishna Kumar, so-called mediator, were also not placed on record under these circumstances, except at this juncture, except the alleged confession statement of accused number 1 and 2. There is no material evidence placed to show that the present petitioner is either a receiver, seller, purchaser, or financer. The next one, the learned council, the learned CGC further invited the attention of the court to section 37 of the NDPS Act regarding reverse owners, but the provisions of reverse owners can be made applicable only if prima facie material evidence regarding possession, conscious possession is established, but that is not the case, and the entire case of the prosecution is based on confessional statement of accused number 1 and 2. Looking to these facts and circumstances, he has further placed reliance on a decision reported in AR 21 SC 4476, but the facts and circumstances of the said case are entirely different. In the said case, the heroin of 3.3 kg which was commercial quantity, was hidden under wiper in front of bonnet car, and the petitioner was a occupant of the said car. Hence, in that context, the Honorable Apex Court has observed that absence of possession of contraband on person of accused does not absolve it the level of scrutiny required under section 37 subclause 1 subclause B subclause 2. Here, it is not case of personal recovery or recovery in person. The entire case is based on there is personal recovery from accused number 1 and 2, and as against accused number 3, the allegation and the entire case is based on confessional statement. Hence, the principles enunciated in the above cited decision cannot be made applicable to the facts and circumstances of the case in hand.
Another statement have to be also.
Next, the learned counsel has further placed reliance on a decision reported in AR 2000 SC, CGC 3661, and invited the attention of the court to section 37, section 52 and 57 regarding grant of bail and its implication. He has also argued regarding reverse burden. Section 37 and under section 37, the accused can be released on bail if it is opposed by the prosecution when the court is satisfied that there are reasonable grounds for believing that he is not guilty of the such offences. In the instant case, except the confessional statement of accused number 1 and 2, which is inadmissible in evidence, there is no other material, and as such, this section 37 does not, section 37 of NDPS Act does not come in the way of granting the bail to the present petitioner looking to the peculiar facts and circumstances of the case in hand. Under these circumstances, without expressing anything on merits of the case, in my considered opinion, the petitioner is entitled for bail, but subject to certain conditions. Hence, the petition needs to be allowed and accordingly I proceed to prosecution. Petitioner is in the on executing a personal bond for rupees 2 lakhs, two sureties for like sum, two local sureties for like sum.
The resident of Bangalore.
Local sureties and Thakta idin, sir. Huh? Two local solvent sureties for like sum. Other normal conditions.
More than that, Krishna Kumar ಅಂತ ಇದೆ. Krishna Mohan Tiwari ಅಂತ.
Krishna Mohan Tiwari. Yes. ಯಾವ್ದಿದು? ಸಿರಿ?
41.
ನಿನ್ನಿದು ಇವತ್ತು ಹಾಕಿದ್ವಿ. ನಿನ್ನಿದು. Yesterday is not very confusion. I don't know. CC footages. ಗೊತ್ತಾಯ್ತು. Vehicle belongs to A1. Yes, sorry, present petitioner. Vehicle belongs to present petitioner. Yes, that is the yesterday I asked certain questions.
Because A1 was working in a garment factory as a driver. Even at the relevant point of time, he was being arrested. So, my lord, I think you last, I can't say now, as you
That may go against you. I'll make it very clear.
Because this stage, my lord, unless I put a material, but he was taken in my vehicle in my objects or somebody, it's a one part. Then, my lord, see in the CCTV footage, he is not visible.
I'm not disputing 100%. In CCTV footage, one thing is certain that accused number 1 got down,
Yes,
the vehicle moved,
yes.
vehicle number is identifiable. Vehicle number is identifiable. It may not be identifiable here, but if it is zoom ಮಾಡಿದ್ರೆ vehicle number is easily identifiable. Otherwise, ಅಲ್ಲಿ ಅಷ್ಟು CCTV ಕ್ಯಾಮ್ರಾ ಹಾಕೋದು ಅವಶ್ಯಕತೆನೇ ಇರಲ್ಲ ಅವ್ರಿಗೆ. ಅಲ್ಲಿಂದ ದೂರನಿಂದ ಯಾವುದೇ ವೆಹಿಕಲ್ ನಂಬರ್ ಕಾಣುವುದಿಲ್ಲ ಅನ್ನಕ್ ಬರಲ್ಲ. Vehicle number can be easily traceable, but that is the reason normally the traffic violators receive the messages violation, pay fine. So identity of the vehicle is not a serious issue. No serious issue. Now, question is, according to the prosecution, the present petitioner accused number 2 was driving the vehicle. According to you, your presence cannot be established from that CCTV footage 100% correct. But the fact remains, then burden shifts on you. You being the owner and possessor of the vehicle, you'll have to explain who has taken the vehicle, when he has taken, for what purpose he has taken. Otherwise,
No, as your lordship.
Simple thing.
As a lordship, right now, my lord, even I say against the even unless there is evidence. And that is a my lord, because question of my lord by the absolutely I have no motive against absolutely no motive. In fact, my lord, I secured a house to her. I also paid even her own statement.
There are certain things wherein the motive is also alleged. At the instance of accused number 3 and accused number 2, the motive is alleged. Accused number 3 given the expressed before A2 in term given the contract to A1 and he himself has dropped. That is one aspect.
Yes.
There is certain motive is alleged, prima facie. Whether that motive is a genuine motive, that is not, cannot be considered here yet. This is too early. But the fact remains that vehicle belongs to you.
My lord, I don't deny, my lord, I don't. deny.
Then how the vehicle?
They say, my lord, unless again you lordship ask me.
Then
Where is the material? Where is the material?
quite natural.
That is the reason, my lord, even I say, my lord, absolutely, because he was a driver, he's a friend of A2, he might have taken the vehicle, even driven, he's a driver, my lord, actually working for the.
But that is not, again, you cannot argue it because the moment A1 got down, the vehicle did not stop there, it moved. But that way, somebody should be there in the vehicle.
That is my lord.
Then who is the best person?
At this stage, my lord, I think the lordship also, I can't discuss at this stage. And again, if I disclose, again, he will be brought back. It's necessary, my lord, I will be getting somebody at this stage. Absolutely, my lord.
Then what stage you are going to do it?
Absolutely, my lord, because the person who committed an act, my lord, is against all case, and absolutely there is no necessity for the my lord committed such an act. And similarly, my lord, the A3 also put in the same footing. She was been granted bail because as
The A3 is different. Allegation against A3. Allegations against A3 is entirely different. She has entrusted to treat this matter to A2. But simple case of you entrusting it to A1, things would have been different. But your vehicle is used.
Well, except vehicle, my lord, my participation of this petitioner absolutely not been. No connection.
Yes.
Vehicle, involvement of the vehicle of this petitioner is strong private. Shows the participation of other statement.
What is the further statement? What is that further statement?
Please, page 48.
Page 59.
48 typed page. And 46 is the lordship's handwritten statement. 48 is typed.
Her further statement is based on CCTV footages, not her voluntary statement. ಹಿಂಗಾಗಿದೆ ನೋಡು ಈ ಕಾರ್ ಬಂದಿದೆ ಕಾರ್ ಅವನಿಗೆ ಸಂಬಂಧಪಟ್ಟಿದೆ ಅಂತ ಅದೇ ಅವಳಿಗೆ ಹೆಂಗ್ ಗೊತ್ತಾ ಅವಳ ಪ್ರೆಸೆನ್ಸ್ ಕಲ್ಯೂಷನ್ ಮಾಡಿದ್ರ then that was not there earlier. She has never suspected A2. I do consider that complaint is not an encyclopedia. 100% correct. The allegation is that you are the cause for desertion by the wife and children of A2, the present petitioner.
Residing with me, my lord, even now I can secure my house.
Swati Vitbidi, we're not concerned with, we are concerned with Ramesh. Ramesh ne ಹೆಂಡತಿ ಮಕ್ಕಳು ಅವ್ನು ಬಿಟ್ಟು ಹೋದ್ರು because of your acquaintance with Swati and the present petitioner. So your case is that therefore Swati and this person decided that she can be defaced so that better opportunities will be given to Swati. Only because since he is a drama artist, beauty is the first cry. That is the only allegation. Howda? Petitioner has filed the petition under section 449 of CH for enlargement on bail in Nandini layout is crime number 59 of 22, registered for the offences punishment 326A and 448 of IPC. The brief factual matrix throughout the Learned Council for Petitioner, Learned HCGP for respondent state. Where is the records? The brief factual matters leading to the case are that on 18/3/22, the SHO has received information from BMC Hospital, Bangalore, wherein the injured complainant was admitted in the hospital, and immediately he went to the spot, and it is revealed that the complainant is residing in the address given by the complainant, and she has taken the house on lease. She is having 2 children who are residing along with her. According to the prosecution, the complainant used to is a working in BMTC 7th depot as a conductor, and during leisure hours he used to practice drama, and her husband were expired about 3 years earlier. It is further the case that due to her health conditions she has obtained VRS and started to work as a drama artist, as a professional drama artist. According to the prosecution, on 73/22 at about 10:30 p.m., she and her children were, after dinner, went to sleep. And on 18/3/18 at about 4:30 a.m., an unknown person threw plastic bottle inside the house, which was cut half, containing some chemical substance, and the said chemical substance spilled over her face, back and shoulders, and as such she woke up and she started feeling burn. Then when she is unable to tolerate the burning sensations, she was shifted to KC General Hospital, wherein she was obtained first aid treatment, and then she was taken to Victoria Hospital, Bangalore, wherein she lodged a complaint regarding unknown persons making attempt of acid attack on her. Later on the basis of CCTV footages, it is alleged that accused number 1 has thrown the acid from the acid on accused number the present petitioner in the house of present petitioner, and the present in the house of complainant, and the present petitioner has dropped the accused number 1 by showing the house of complainant. In this regard, the present petitioner was also implicated and he was arrested and remanded to judicial custody. The petitioner was interrogated and subsequently, after completion of the investigation, investigating officer has submitted the charge sheet. The petitioner who is arraigned as accused number 2 has approached the learned session judge, and learned session judge has rejected the bail petition filed by the present petitioner, regular bail petition filed by the present. Hence, petitioner is before this court. Having heard the arguments and perusing the records, it is evident that some mild quantity, the mild concentrated acid was thrown in the house through window wherein the complainant was sleeping, and she suffered certain burn injuries on her face and other parts of the body. It is the allegations of the prosecution disclose that on the basis of the CCTV footages, it is evident that the vehicle of the present petitioner, accused number 2, is used for dropping accused number 1. The prosecution alleges that the accused number 3 has conspired as she was denied proper opportunities to work as a drama artist in lead role because of the present complainant. She conspired with accused number 2, that is the present petitioner. Further, as per the case of the prosecution, because of the complainant, the wife and children of present petitioner have also deserted, and hence the petitioner has also joined hands with accused number 3, and he entrusted the matter to accused number 1 and dropped him at the spot by showing the house of the complainant, and later on picking him after the incident. On the basis of these allegations, he was prosecuted. However, on perusal of CCTV footages, it is evident that the vehicle of the present petitioner is being used for dropping accused number 1. But there is no material evidence at the juncture to show that accused number 1, the petitioner was driving the said vehicle. However, it is for the petitioner to explain how his vehicle was used and who was driving the said vehicle, as the CCTV footage discloses that after dropping the accused number 1, the vehicle moved further, and later on, after taking a U-turn, it again came to the same spot and picked up the accused number 1. However, the records further, the allegations further disclose that the statement of the witnesses further disclose that the petitioner and accused number 1 have purchased the acid, but the records disclose that it was a low concentrated acid. No grievous injuries have been suffered by the present petitioner. The investigation is also concluded and charge sheet has been laid down. Nothing is required to be recovered from the custody of the petitioner. Looking to these facts and circumstances, I do not find any impediment for acquitting the petitioner on bail. The other apprehension, the wound certificate disclosed that petitioner has suffered only 14% superficial burn injuries on her face with swollen eyes, but there are no other grievous injuries. Considering these facts and circumstances, the petition will require to be allowed. The The other apprehension can be meted out by imposing certain conditions. Hence, petition is to be allowed. 2 lakhs with 2 sureties per lakhs. Legal counsel for petitioner called out as least after 2 weeks. The legal counsel for petitioner called out as there is no representation followed on least after 2 weeks. Yes, sir.
Petition under 439. Offense under 303. Petitioner is the sole accused. The incident happened on 5th of April 2021, around between 8:45 and 9 in the morning. But actual background is
Yes.
the petitioner and this Tim Malott, who's a young girl of around 17 years of age. They belong to the same village called Otagola village of Sira Taluk. Apparently, petitioner was in love with this girl, and this girl was not reciprocating his feelings. But on the date of the incident, the deceased, along with the CW225, the morning was walking to catch a bus to her college. She was a student of first year PU, pre-university, the government arts college at Sira. While she was on the way, my lord, the petitioner comes there, his motorcycle, and he calls her to accompany him. She refuses to accompany him. Then he parks his vehicle, holds her by the hand and pulls her. When CW225 try to stop him, he threatens them with a sickle. Thereafter, my lord, he takes her to the land of one Malana, adjoining land of one Malana. He tries to tie a tali around her neck. When she resists and slaps him on the face, he indiscriminately assaults her. Around 13 injuries on the face, neck, and hands. He dies on the spot. CW1, my lord, is the eyewitness. He was in the adjoining land. He hears the cries and he immediately rushes there. By then, he'd have received a telephone call from one Harish saying that, see, this person, petitioner, is troubling that girl of the daughter of CW1, Pandurangappa. So when he hears his cries, he rushes in that direction and he sees the petitioner assault. And by then, CW12, father of the deceased, also comes there. And this man runs up, petitioner runs up. This is the prosecution. She dies on the spot. Same day, my lord, the complaint is filed at around 10:30.
case is registered. And next day, in the morning, petitioner is arrested. That is on the 6th of April 2020. And weapon is recovered. It is used for other assault. Uh, 164 statements of CWs 2 to 5, who are all the friends of the deceased, who are accompanying her that day. It's also recorded. And now charge sheet has been. But my submission would be, this stage, I will not be able to report a case for the grant of bail. But
One way love affair.
sorry,
One way love affair.
one way love. But he could not.
There is no reciprocal response from the other side. Finish it.
Yes.
ಈ ಲವ್ ಮಾಡ್ಲಿಲ್ಲ ಮತ್ತೆ ನೀ ಯಾಕೆ ಬದುಕ್ತೀಯಾ? ಫಿನಿಶ್.
Submission. 6th of April 2020. Till date. That has a trial also. Has not. All I am seeking from this one direction. Well, 6 months or 8 weeks, some reason. That's all.
So you withdraw.
My friend happens to be the Catholic of
Yes, fairly straight way submitted. So I appreciate it. And that is expected from the bar only. Huh? Because normally we blindly trust, but the submissions made at the bar will trust. And if such submissions will be there, it will be very easy for the court. Learned counsel for petitioner submit that he may be permitted to withdraw the petition with a direction to the concerned trial court for expeditious disposal of the main matter itself on merits. The submission is placed on record. In view of the submission, the petition is dismissed as withdrawn. Next, the concerned trial court is hereby directed to dispose of the case by concluding the trial within a period of 12 months, within an outer period of 12 months from the date of receipt of the certified copy of this order. It will make very easy for the court, sir, if such submissions will be there.
This is 439 petition for offense under section 3, not to IPC. We accused this is the first accused. Petitioner is the first accused. In nutshell, prosecution case is that one Bhavya, Srimati Bhavya, wife of deceased व्यक्ति, appears before the police and makes allegation that she received a telephone call from her brother-in-law. Her brother-in-law informed her that her husband has been done away with some unknown weapon by Hanumantegowda, Nagaratna and Gangamu. She comes to the police station in the evening and lodges the complaint with the police. During the course of investigation, the police arrested the petitioner on the same day and produced next day on 3rd of April before the Magdi police. They were remanded to judicial custody. In nutshell, the prosecution case is that there was a dispute over unknown mobile, a button mobile unknown, make not known, mobile phone number not known. There was a dispute over the lost phone between Gangamma and the deceased. Deceased went to the house of Gangamma to demand his mobile phone. She said she don't have the mobile phone, she don't know his mobile phone. Then he assaulted her. Deceased Jagdish assaulted one Srimati Gangamma who is cited as A3. Then there was a couple holding and other thing. Hearing the noise near his house, it is a village of half a kilometer dimension. Her son even comes near the place of incident. Seeing even the petitioner, the deceased tries to run away from the place of incident and slips near a drainage water, percolating drainage water. There he slips and falls down. By the time Hanumante Gowda, the petitioner, go there, he picks up a small club laying there on the spot and assaults him on the head. His sister Gangamma, Nagaratna was actually, she also seeing the scene comes to the place and assaulted on the head with the same club to the deceased. He died on the spot. Not due to the injury sustained, it is due to the regurgitation. That the food particles had come to his mouth and to his lungs, and he had died.
Why the food particles come to his lungs?
That is medical terminology. It is a disputed thing. My lord, it is sometimes regurgitation may happen due to hyperacidity, hypertension, or drinking. He was having disease, was chronic drinker. He was a deserted. He was residing even on the streets. He was such an addict, day and night. That is not on the river.
Then
But
you are-
regurgitation happens and particles enters his lungs.
How they entered is a question.
Yes.
There should be some reason for entry.
When a person has got regurgitation in his mouth,
You have not produced the PM report.
His
You have not produced PM report.
PM report is
You are not produced. I am simply asking. Why you are not produced PM report?
I submitted.
You have submitted. You have produced the charge sheet, only relevant one inquest and the front page of the charge sheet, nothing more.
My lord, I
All
had
other parts of the
submitted-
charge sheet were withheld by you. Why?
My lord, I had submitted the charge sheet in under petition. Other two petitions were before total number 16. There I had submitted 2 copies. That
Take this to total number 16. I have no objection.
and that both A2 and A3 are admitted to them.
Correct. A2, 100% because this is petition filed by A1 alone. After allowing the petitions filed by A2 and A3, this petition is filed.
That's sir, one I said.
I am not. After allowing first the petitions of A3 was moved, then A2 was moved. Both were allowed and then A1 was moved.
Pending the
Chronologically.
petition.
Is it not?
Pending the petition.
Is it a fact or not?
Yes, sir.
Because minimum allegations against A3, then lesser allegation against A2, maximum allegations against A1. So chronologically, step by step petitions.
Act is one I said. He-
Act is one and same. He was quarreling with accused number 3.
He had not the character. A3.
The deceased was quarreling with A3. The dispute was regarding mobile, which was alleged to be in custody of A3. She refused to return. Verbal exchange of words taken place. Hearing this noise, A1 rushed to the spot. Seeing A1, he fled. The deceased fled. On the way, he slipped, fell in the nala.
Exactly right.
Then he was assaulted on the head by A1 by the club. The same club is again used by A2 to assault. So first blow is given by A1. That was the
Yes.
correct. History
Yes,
law
definitely,
case.
exactly.
Then-
To appreciate the facts.
So now you are arguing that death is because of the food particles came to the entered in the lungs. Where is the PM report? PM report, nature of injuries, cause of the death, everything will be disclosed. The reason for fluid particles, because once the things, grievous injury, what will be the consequences of head injury?
It is only greatest, and producing and will be permitted. Sorry,
Memo hachkodi ನಂದೇನೋ ತಗೊಂಡು ಮೆಮೋ ಹಚ್ಕೊಡ್ಬೇಕು ನೀವು. ನಾನು I will not accept it in a casual way.
Yes.
You are officer of the court, maintain the decorum of the court. ಮೆಮೋ ಹಚ್ಕೊಡಿ, ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀನಿ.
After submitting.
ಅದನ್ನ ಕೂಡ ಅದೇ ಮಟೀರಿಯಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅದನ್ನೊಂದು ಪ್ರೊಡ್ಯೂಸ್ ಬಿಟ್ಟು ಎಲ್ಲಾ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ ನೀವು. ಮೆಮೋ ಹಚ್ಕೊಡಲ್ ಕೊಟ್ರೆ ನೋಡ್ತೀನಿ, ಅದರ್ವೈಸ್ ನೋಡಲ್ಲ. Ground of parity will not be made applicable to you. ಮೊದಲೇ ಹೇಳ್ತೀನಿ. Granting bail to other two ladies, the fact is that they are ladies. Overt act alleged against them is very different, and especially no specific overt act is alleged against A3, that is your mother. So ground of parity will not be assisting you in any way. Then
There is no motive, intention, preparation is alleged as a. It was accidental. He heard.
it is not an accidental.
No.
Yeah, even if your arguments are accepted and appreciated, it will fall under 304. It may not be 304. That is to be considered by the session judge.
Yes, at the time of.
I cannot express. The moment I express, you move an application for alteration of the charge.
Yes.
I'll not express anything.
But the facts are that he had not had any intention, motive, or he had not made any preparation to attack him, and he was not carrying any weapon. It was as per charge. It was laying on the.
It was laying, but there was no sudden provocation. Why? What was the provocation? He has not given. The deceased were running away.
Yes.
There was no provocation. Grievous injury. What was the nature of injury
He was
sustained?
admitted in the human house.
What was the nature of injury sustained by that lady?
That lady was admitted in the human hospital.
For what purpose?
For the head injury.
Who has caused the head injury?
This is a.
Where is that FIR? Where is that FIR?
That the observation has been made by the session judge, but it is nowhere shown in the charge sheet or FIR. She has not lost the head. This was unconscious.
Okay, sir. First thing. So according to you, the deceased has assaulted your mother on her head. Correct. Then he after seeing the present petitioner, he started running away. You chased him. You chased him. He slipped, fell. You attacked him by club on his head. Correct. One day injury, ಎರಡೇ injury. One blow is sufficient to finish off everything.
That is skin deep only. That injury is only skin deep. It is not of such a great, it has not broken the skull, it has not caused the previously.
Here is the evidence. PM report produce ಮಾಡಲ್ದ ಎಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ ನೀವು. ನೀವು PM report produce ಮಾಡಿಲ್ಲ and you are arguing against the medical evidence.
Sorry, madam. The two charge sheets were submitted before the honorable court.
Two charge sheets.
Means copies, two certified copies.
I don't want two certified copies. I want only one certificate. 2 years, ಎರಡು certified copy ನೋಡ್ಕೊಂಡು ಭಾಳ ಏನು ನಾನು ಎಕ್ಸ್ಟ್ರಾ ಮಾಡ್ಬೇಕಾಗಿಲ್ಲ. ಕೊಡಿ.
a single eye vision to the incident. Not even a single person has seen Umante Gowda assaulted him.
Where is the final opinion?
I never took opinion. Column number 100.
Where is the final opinion? Because this result pending for want of chemical analysis and histopathological examination reports. Where is that? Then how you are arguing that it is only because of food particles entering the,
What is
there is, when final report is not there, how can it be observed? Final opinion is still pending.
It is a defective chassis submitted on the last date of.
Sir, one thing is certain, he suffered brain head injury. The PM report disclosed that the cerebellum shows subdural subarachnoid hemorrhages at the places at its base. Though skull is intact, subdural hematoma is there.
Maybe due to the fall from a drunken person falling.
It is not the case
Chances are there, it may be due to the fall, man.
due to the fall. What is the evidence that he is a chronic drunkard as argued by you?
Not based on record.
Then how can I, oral submission, how can it be accepted,
He
sir?
was staying alone, his wife had deserted him, his brother had deserted him. And allegation is made regarding your mobile. Not even wife knowing the mobile number, brothers knowing the mobile number, make up the mobile, nothing about the mobile, no description, no number. It is surprising. A wife does not know her husband's phone number. Brother does not know phone number.
ಏನೋ ಒಂದು ಬೇರೆ ವ್ಯವಹಾರಕ್ಕೆ ಇಟ್ಕೊಂಡಿರ್ಬೋದು, ಯಾರಿಗೂ ಹೇಳಿರ್ಲಿಕ್ಕಿಲ್ಲ. That is not expected. Sir, but the one thing is certain, blow was on the head. Because he did suffered other injuries when he fell, certain abrasions on the shoulder, right arm, everything is there. But this head injury was 12 centimeter in length from occipital top to the ear. It is not a, then
Injury. So it is in length, it is not deep. It has not broken the skull.
do you mean to say that only skull, if the skull is broken, it leads to the complication? Because what the medical report disclosed, the PM report, there is hemorrhage is there, subdural hemorrhage. And that hemorrhage is not in single place, at multiple places. And hemorrhage can occur only because of the head injury.
But that is not due to Henry.
Where is it?
Regurgitation.
Where is it?
Food particle.
Where is it?
Opinion, medical opinions into the food particles enter in the lung.
ಎಲ್ಲದರ ಇದು? Because this PM report does not say mouth pharynx intact, congested, stomach contents so and so, small and intestine so and so, gas contents, kidney and other things intact, injuries to head. PM lividity seen over the back surface of the body. Omitted food particles are present over the mouth and nostril. That is not because, that is because of the head injury. The moment the head injury causes subdural hemorrhage, whatever you intake, it will come out. It will come out. Because the digestive system completely stops suddenly. Then it doesn't show anything. What you have argued, no.
It is not a final method. It is interim.
Then why you have come to before the court? Unless there is a final opinion.
Final
Withdraw it. Otherwise, I'll dismiss. 302 is there. 1 and 2, 2 and 3 are granted bail. They are ladies, absolutely no issue. And the overt act alleged against them are entirely different. But major overt act is alleged against you. You can withdraw. Otherwise, I'm going to dismiss it.
We had not had made anything. Not had-
See, that is a different aspect. At this juncture, this is too early. This is too early.
It is not anticipated.
Hmm. You are in custody since last 7 months.
Then
3, 4, you have been arrested. 3, 4. 7 months you are in custody, but that itself is not a ground at this juncture. ವರ್ಷಾನುಗಟ್ಲೆ ಕಸ್ಟಡಿ ಒಳಗಿಲ್ಲ ನೀವು. And we are supposed to consider the death of a human being. That is also serious, because if your act, one person has lost his life, that cannot be ignored. His right of liberty completely what we have here.
you might not have anticipated that.
The question of anticipation doesn't arise, because when you are targeting head,
Maybe two chances are there. One because of the trauma and another because of the injury caused by the petition. He might not have anticipated that laying there could definitely and certainly cause the death. That intent. He should have the knowledge.
so these arguments hold good for alteration of the charge. For 302, 304, either part 1 or part 2, it is, I cannot express anything.
There is caused with the knowledge and the belief. The intention.
When you are attacking on a head, law expects that you should have knowledge. What will be the consequences? What will be the consequences if a person attacks on the head?
It is alleged that it is like laying there.
Yeah, whatever it
Laying
was.
there, he had not bought it from home. He had not gone to any place. They checked the weapon. It was by chance it was alleged to have.
But
been
anyhow, not a fit case at this juncture, sir. This is too early.
taken.
Arguing the matter for some time, the learned counsel for petitioner submitted that he may be permitted to withdraw the petition. The submission is placed on record. Dismiss as a ground. Huh?
Present petition.
With a liberty,
In the event of filing final FSA report.
with a liberty to move before the session judge for similar relief if he is advised to do so. ಹಿಂಗೆ ಬಿಟ್ಟಿದ್ದೀನಿ. ಎಸ್ ಮೇಡಮ್, ನಿನ್ನೆಯಿಂದ ನೀವು ಕಾಣ್ತಾನ ಇಲ್ಲ, ಈ ಬಂದಿದ್ದೀರಾ ಹೇಳ್ಬಿಡಿ. ಅವ್ರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೇ ಆಯ್ತು. ನಿನ್ನಿನ್ನೂ ಹೇಳಿದವ್ರು ಪತ್ತೇನೇ ಇಲ್ಲ. ಪಾಸ್ವರ್ಡ್ ಆದ್ಮೇಲೆ ಸಾಯಂಕಾಲ 5 ಗಂಟೆಗೆ 5:15 ರೀಚ್ ಆಗುತ್ತೆ. ಅವಾಗೆ she is waiting since last 3 to 4 adjournments. and one or the other way, you are successful. ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಮೇಡಮ್, ಗ್ರಾಂಟ್ ಆಗುತ್ತೆ ಇಲ್ಲ ರಿಜೆಕ್ಟ್ ಆಗುತ್ತೆ, ಎರಡರ ಒಂದೇ. He has also argued. Now you are ಮದುವೆನೂ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ, ಫೋಟೋನು ತೆಗಿಸ್ಕೊಂಡಿದ್ದೀರಾ. ಪೇಜ್ ನಂಬರ್ ಎಲ್ಲಿದೆ ರೀ? ಪ್ರೊಡ್ಯೂಸೇ ಇಲ್ಲ. ಯು ನಾಟ್ ಪ್ರೊಡ್ಯೂಸ್ 164 ಸ್ಟೇಟ್ಮೆಂಟ್. ಯಾವ ಪ್ರೊಡ್ಯೂಸರ್? ಪೇಜ್ ನಂಬರ್ ಎಷ್ಟು? The complaint is lodged by the victim herself. Correct? You have produced a certain WhatsApp exchange of messages disclosing that it appears to be a love affair. In that event, why the victim shall lodge a complaint against you?
And inform the fund to go to the station and the father has been getting on. And
ನನ್ನ ವಿದ್ಯಾಭ್ಯಾಸನ್ನೆಲ್ಲ ಅವನೇ ಹಾಳು ಮಾಡಿದ. ಆ 26/11/21 ನಾನು ಕಾಲೇಜಿಗೆ ಹೋಗ್ತಿದ್ದೆ. ಅದೇ ದಿನ ಮಧ್ಯಾಹ್ನ ಸುಮಾರು 1 ಗಂಟೆ ಕಾಲೇಜಿನಿಂದ ಹೊರಗೆ ಬಂದು ಅಂಗಡಿ ಮುಂದೆ ನಿಂತಿದ್ದೆ. ಆಗ ಗೋವಿಂದ ಹಾಗೂ ಶ್ರೀಧರ್ ಬಂದು ನಾನು ಬರುವುದಿಲ್ಲವೆಂದರೂ ಸಹಿತ ನನ್ನನ್ನು ಎಳೆದುಕೊಂಡು ಕಾರ್ನಲ್ಲಿ ಕರೆದುಕೊಂಡು ಹೋಗಿ ಹಾಸನ ಅವ್ರ ತಂಗಿಯ ಮನೆಯಲ್ಲಿ ಕರೆದುಕೊಂಡು ಹೋಗಿ ಅಲ್ಲಿ ಸ್ವಂಚು
provided on 2/12/2021. Has provided the information. So far as it is concerned.
How you overcome 164 statement ಅಂತ ಕೇಳಿದ್ ನಾನು ಅಷ್ಟೇ.
Doubt behind that.
What doubt?
So far as regarding the first time, the victim has already second and
Our complaint to other, the complaint is lodged by the victim. Victim father complaint ಕೊಟ್ಟಿದ್ದು 363 ಕೆಳಗೆ missing complaint. Subsequently, when victim was traced, she has lodged a complaint, written complaint.
But the victim, as per according to her information provided to the victim, so she stated that the Govind Raju victim has come and taken me and went to sister's house and stayed for 1 night.
One night there was a
In Bangalore. After 3 days, I was staying with his sister's house and I received call from the Govind Raju to go police station and so complaint has been registered. Then she went approach to the police station and police have referred to the hospital to conduct the examination. So thereafter, to compare with the age of the.
What is 164 statement? What is 164 statement? Forcibly kidnapping her from the spot in a car along with another accused.
Another accused is the sister's husband.
Whatever it may, I didn't say anything. Along with another accused ಅಂತ ಇಷ್ಟ ಹೇಳಿದ್ನ ನಾನು ಅವನ ಬಗ್ಗೆ ಏನು ಉಳಿಕಿದ ಏನು ಹೇಳಿಲ್ಲ. Along with another accused kidnapped her in a car, taken her to your sister's house, wherein you stayed night, where there is an allegation of sexual assault, and then taking her to Bangalore, having a room, there again committing sexual assault, getting information regarding lodging of the complaint, and you have asked her to go on to Hale Narsipura police station. This is the 164 statement. How you overcome 164 statement? Mistake. Why she should give a?
So she got married with the accused. So far as the age.
She is married to accused. Ellide? In her entire statement, there is no reference regarding she marrying the present petitioner. Now you are making a case of she marrying. ಒಂದು ದೇವಸ್ಥಾನ ಮುಂದೆ ನಿಂತು ಹಾರ ಹಾಕೊಂಡಿದ ತಕ್ಷಣ ಮದುವೆ ಆಗೈತೆ ಅಂತ ಹೇಳಲಿಕ್ಕೆ ಹೋದ್ರೆ he will be again prosecuted for child marriage, prohibition of the Child Marriage Act.
Ready to marry his son, but continuing the relationship. But you have the directions of the debate now the age of the.
ನಾನು ಅವ್ರಿಗೆ ಡೈರೆಕ್ಷನ್ ನಾ ಎದಕ್ಕೆ ಕೊಡ್ಬೇಕು? ನಾನು ಅವ್ರಿಗೆ ಡೈರೆಕ್ಷನ್ ಎದಕ್ಕೆ ಕೊಡ್ಬೇಕು? Why court should direct them? ಅಲ್ರಿ ಅವ್ರು ವಾಲಂಟರಿ ಬಂದ್ರೆ ಕೋರ್ಟ್ನವ್ರು ಕೇಳ್ಬೋದು, ಕನ್ಸಿಡರ್ ಮಾಡಬಹುದು. ಇಲ್ಲ ನಾವು ಮದುವೆ ಮಾಡ್ಕೋತೀವಿ ಬಂದ ಅಂದ್ರೆ ಕೋರ್ಟ್ ಮೇ ಕನ್ಸಿಡರ್ ಇಟ್. You want the court should direct them. How can it be? ಏನಂತ ಹೇಳಿ ಡೈರೆಕ್ಷನ್ to produce the victim ಅಷ್ಟೇ. ಅದಕ್ಕಿಂತ ಹೆಚ್ಚಿಂದ ಏನ್ ಡೈರೆಕ್ಷನ್? ಮದುವೆ ಮಾಡ್ಕೊಳಕ್ ಡೈರೆಕ್ಷನ್ಸ್ ಕೋರ್ಟ್ನವ್ರು ಕೊಡಕ್ ಆಗಲ್ಲ. ನೀವು ಮದುವೆ ಮಾಡ್ಕೊಂಡಿದೀವಿ ಅಂತಾನೆ ಹೇಳ್ತಾ ಇದ್ದೀರಿ, but the victim never asserted that she was married. Neither in her statement before, neither in her 164 statement nor written statement submitted to IO, she never asserted that she was married. Already ನೀವು 34 ವರ್ಷ ನಿಮಗೆ. ಹೌದೋ ಅಲ್ಲೋ ನಾನು ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಅಲ್ರಿ ಹೌದೋ ಅಲ್ಲೋ ಅಂತ ಇಷ್ಟೇ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ನಿಮಗ 34 ವರ್ಷ, 17 ವರ್ಷದ ಹುಡುಗಿನ ಬೇಕು. ನಿಮ್ಗೆ 17 ವರ್ಷದ ಮಗಳ ಹುಡುಗಿ ಬೇಕಾ? ಯಾಕೆ? ನಿಮ್ಮ ವಯಸ್ಸಿನವ್ರು ನೋಡ್ಬೇಕು, ಮದುವೆ ಆಗ್ಬೇಕು. ಚಿಕ್ಕ ಮಕ್ಳು ಎದಕ್ ಬೇಕು ನಿಮಗೆ? ಎಸ್. Okay, sir, consent cannot be, but she is capable of understanding what are the things that are going to happen. That is one aspect. She knew, she is capable of understanding. She was aged about 17 years. What is your explanation regarding she taking a different posture photographs with the present petitioner? ನಾನು ಕೇಳ್ತಾ ಇರೋದು ಅದು ನಿಮ್ದು ಮ್ಯಾಟರ್ ಆಫ್ ಟ್ರಯಲ್ ಇದೆ. ನಾನು ಕೇಳ್ತಾ ಇರೋದು what was the interest of the victim to take a different photographs as a model along with the present petitioner? ನಿಮ್ಗೆ ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನೋಡ್ಕೊಳ್ಳಿ. ನಿಮ್ದು ಅಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಪ್ಲೀಸ್ ಅಂತ. Then how you overcome these photographs? ಅದು ಮಾಡೆಲ್ ನಂಗ ಫಿಲ್ಮ್ ಸ್ಟಾರ್ ಒಳಗ ಫೋಟೋ ತೆಗಿಸ್ಕೊಂಡು ಕೊಡ್ತಾ ಇದ್ದೀರಿ. There is no compulsion in taking those photographs. Compulsion ಇಲ್ಲ. ಹೇಳಿ. Also India investigation material one-sided ಅದು ಅದ್ನಂಗ ಇದರ part of ಇರುತ್ತೆ. It is now the by way of defense they are producing it. It cannot be a part of the investigation. They are saying that it is out of love affair and she has voluntarily cooperated. Her consent may not be relevant because of her minority, but the fact is that she is capable of understanding the things is to be considered. In consent. What is consent? I never said that it is a consent, but the fact remains that it is not that consent doesn't have any relevance, but at the same time, her conduct, having capable of understanding the things, having grown up, that also becomes relevant. There are category of decisions. ನೀವೇ ನೋಡ್ಕೊಳ್ರಿ ಫೋಟೋಸ್, ನೀವೇ ಹೇಳಿ ಯಾಕೆ. And why the victim is not apprehending to appear before the court. Then ಇಲ್ಲಿವರೆಗೆ ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಟ್ಟ ಮೇಗೂ ವಿಕ್ಟಿಮ್ ಬರ್ಲಿಲ್ಲ. ಯಾವಾಗ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿರ್ತೀವಿ ಮಾರ್ನಿಂಗ್ ಅವರ್ಸ್ ಟೈಮ್ ತಗೊಂಡು ಹೋಗಿದ್ದೀರಿ. ಆಯ್ತು, ಈವ್ನಿಂಗ್ your allegation is that victim was not allowed to appear. Now he is undertaking to keep the victim present. Yesterday you made allegations, late evening. Yesterday evening you made allegations that there was a direction, they are not producing, they are taking time. Now he undertakes ಒಳಗ್ ಕಳಿಸ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿ. Now his submission is that it is matter was not reached, therefore that she could not appear before the court. Now he sir, madam, have patience. Now he undertakes to keep the victim present. What you have to say? ನೀವು ಮಾತಾಡಿದ್ರೆ ನಾನೆಲ್ಲಿ ಹೇಳಿದೆ? ನಾನ್ ಕೇಳ್ತಾ ಇರೋದು ಈಗ ನಿಮ್ದು ವ್ಯಕ್ತಿಯನ್ನ ಕರೆಸ್ತೀನಿ, ನಿಮ್ಮ ಸಮಕ್ಷಮ ಅವ್ರ ಸಮಕ್ಷಮ in a camera proceedings will consult the victim. What have you got any objection? Fair ಆಗಿ ಹೇಳಿ, ಧೈರ್ಯದಿಂದ ಹೇಳಿ. Don't take anything to personal. ಅದು ಏನು ಆಗಲ್ಲ ನಿಮ್ ಕೇಸು. Be professional. Monday. Keep Monday victim present. No, tomorrow I will not be sitting. You get here between 1:30 to 2:30. We'll discuss with her in presence of both the courts. Sunday. You come directly to at 1:30. ಆಯ್ತಾ? ಮಂಡೇ ಹಾಕಿದ್ದೀನಿ. ಬಿ ರಿಪೋರ್ಟ್ ಇರ್ಲಿ, ನೀವೇನ್ ಮಾಡ್ತೀರಾ ಹೇಳಿ. ಈಗ ಏನಾಗ್ಬೇಕಾಗಿತ್ತು ನಿಮಗೆ? ಅದು ಬಿ ಆಗ್ಲಿ ಸಿ ಆಗ್ಲಿ, ನಿಮ್ ಪಡಿಷನ್ ಅನ್ನು ಏನ್ ಮಾಡ್ಬೇಕು ಅದನ್ನೇ ಒಂದು ಹೇಳಿ ಸ್ವಾಮಿ. ನಾಟ್ ಪ್ರೆಸ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ, ಮತ್ ಯಾಕೆ ಟೆನ್ಷನ್ ಮಾಡ್ಕೋತಿದ್ರ? ಅವ್ರು ಹೇಳೋರು ಹೇಳ್ಬೇಕು. ಎಸ್ ಸರ್. ಸೀರಿಯಲ್ ನಂಬರ್ ಹೇಳ್ಬೇಕು, ನಮ್ಗೆ ಗೊತ್ತಾಗಲ್ಲ. 15. If it is, I will check it, and if it is complied, we will issue notice to the HCGP and will call his objections.
Serial number 52 now. This had I take out 2 weeks.
52. 438.
439.
239. Kariyappa anyway. 2 weeks as per request. ಏನಾಯ್ತ್ರಿ? ಹಾ. ಏನ್ರಿ ಪಿ ಎಫ್ ತಗೊಳಕ್ಕೆ ನಿಮ್ಗೆ ಎಷ್ಟು ಕಷ್ಟ ಆಗತ್ತೆ ರೀ? ಹಾ ಅಲ್ರಿ, this is the second case. You move a memo, but doesn't take any steps. And you are occupying the slot which could have been utilized by the others. ಏನ್ ಸ್ವಾಮಿ, ಬರ್ಲಿ ಅದನ್ನು ಬಂದ ಮೇಲೆ ಮಾಡ್ತೀನಿ ನೋಡ. ಹೇಳಿ ಮೇಡಮ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇಲ್ಲ, 2 weeks ಹೋಗುತ್ತೆ ನೋಡಿ. That will be then after vacation only. Okay, after vacation in the month of January. After 2 weeks, almost vacation. 2 weeks after.
ಮಾಡೋದಿಲ್ಲ. ಬಂದು
Yes, sir.
Sir, back to appear for petitioner lordship. Success to bail petition lordship.
ಗೊತ್ತಾಯ್ತು, ಮುಂದೆ ಹೇಳಿ ಸರ್.
Lordship, may I start with facts lordship?
You are moving a successive bail petition.
Please, my lordship.
You will have to disclose the change circumstances.
Please. Last occasion, lordship, your lordship has rejected the bail on the basis of charge sheet 90 days ಅಲ್ಲಿ file ಮಾಡಿಲ್ಲ ಅಂತ move ಮಾಡಿದ್ರು lordship. There is no lordship facts and
ಚಾರ್ಜ್
circumstances.
ಶೀಟ್ ಫೈಲ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿ 90 ಡೇಸ್ ಒಳಗೆ ನೀವು ಮೂವ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿ ನಿಮ್ದ್ಯಾಕ್ ನಾವು ರಿಜೆಕ್ಟ್ ಮಾಡ್ಬೇಕು ಸರ್?
Please.
ಏನ್ ಸರಿಯಾಗಿ ನೋಡ್ಕೊಂಡು ಹೇಳ್ಬೇಕು. ಏನ್ರಿ
Please.
ಕತೆ ಹೇಳಿದ್ರೆ ಹೇಗ್ರಿ?
Please.
ಎಸ್
Lordship,
ಹೇಳಿ.
may I the date of incident is on 23/9/2020 lordship.
ನಾನ್ ಕೇಳ್ತಾ ಇರೋದು ಚೇಂಜ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸಸ್ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಸರ್.
Lordship, entire changes circumstances.
Submission of the charge sheet is not a change circumstance, sir.
Please. Lordship is permitted to start once again.
Permitted once again ನೀನು ಹೊಸದಾಗಿ ಮಾಡಕ್ ಬರಲ್ಲ ಸರ್. A elaborate order is passed in criminal petition number 101403/21.
Please.
Huh.
Lordship, your lordship, as the entire recovery is the only from accused number 9 and 10 lordship.
ಸರ್ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಹೇಳ್ಬೇಕಂತೀರಾ 9 and 10 ಗೆ ಅಷ್ಟೇ ಇದೀನಿ ಅಂತ ಹೇಳ್ತೀರಾ? ನಿಮ್ ಪೆಟಿಷನ್ ಅಂತೂ ಒಂದು ರಿಜೆಕ್ಟ್ ಆಗಿದ್ದದೆ. ಚಾರ್ಜ್ ಶೀಟ್ ಇಸ್ ನೌ ಸಬ್ಮಿಟೆಡ್.
Please.
ವಾಟ್ ಆರ್ ದಿ ಚೇಂಜ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸಸ್ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ, ಅದನ್ನೊಂದು ಬಿಟ್ಟು ಎಲ್ಲ ಕತೆ ಹೇಳ್ತಾ ಇದ್ದೀರಿ.
Lordship, changes circumstances.
ಸೀನಿಯರ್ ಕೇಳ್ಕೊಂಡು ಬನ್ನಿ. Just consult your senior.
Please.
Next week ಇಟ್ಟಿರ್ತೀನಿ. You just consult your senior.
Please.
The bail is granted by Natarajan. Cancellation ಅವ್ರ ಮುಂದೆ ಹೋಗ್ಬೇಕಲ್ವ? Our bail is granted by one coordinate bench. And cancellation petition is placed before the other coordinate bench. Whatever it may be, the petition is allowed by this court. This court means the High Court. And now you are moving a petition for cancellation of the bail. That should go before the same judge. Filed, so that is also, your petition also becomes. But
confusing. They have to admit it because though there is a severe conditions because of the Kisano Court. He left the India and he went to the America. Some 3-4 months he was there. Therefore, I filed the application. Immediately he filed like a foreign interpretation and he gets the stay that matter for me. He will be refusing the point.
You are at liberty to contest the bail petition. There is even if now for the sake of arguments, if your petition is allowed also, it doesn't have any.
Either way, I am going to challenge the bail report.
In your bail report, you are at liberty to challenge before the concerned court only. So it can be discussed. The learned counsel for. That is correct. But now it cannot be taken note of.
Technically, my petition may not be served. But there is a gross violation on the part of that.
Learned counsel for respond number 1 has produced, has submitted that the investigating officer has submitted a B final report and produced the copy wherein it is evident that the investigating officer has submitted the B final report of civil nature. Considering this aspect, the learned counsel or petitioner submits that though the violation of the bail condition is apparent on the face of the records, the technically petition is not maintainable and hence he may be permitted to withdraw the same. The submission is placed on record, hence the petition is dismissed as withdrawn in view of the subsequent events. ಯಾಕಂದ್ರೆ ನಿಮಗೂ ಇದಾಗಬಾರ್ದು ಸಬ್ಸಿಕ್ವೆಂಟ್ ಇವೆಂಟ್ಸ್ ಅಂತ ಅದಕ್ಕೆ that is. Yes,
number 153. We are accused in claim number 178. Margate this under section 420, 467, 468. Initially, this is the complaint. Filed a PCR at 76/22 of Margate Court. District court was referred to the Margate police station 156/3. On basis of the PCR, the Margate police have registered a crime 178/22, section 420, 467, 468. According to the allegation, the petitioner along with accused number 2 to 4 we plan to state GPA and GPA in survey number 32/2A 3 acres 30 gunters. landowner is this citizen Saka. They are created in favor of the petition number 1, JMA. He sold the JMA the accused number 2. Transport to the title accused number 2. Thereafter, accused number 2 also transferred to the accused number 3. The complaint was known. She went to the Magdi police station and made a complaint for the purpose of filing the complaint. But they have not received the complaint. Then she filed a PCR against the case. Later, my lord, all the family members are sitting and decided the same deed was cancelled. Complainant and accused persons are the family persons. And cancelled deed executed on 19/8/22. In the meantime, the accused number 2, 3, 4 are granted by the Honorable Court in criminal petition number 79/9/22. I am submission before this Honorable Court. Kindly allow the petition in the interest of justice.
What is interest of justice?
Reason
There is serious allegation in Sakis number 1. He is the beneficiary under GPA. Whether, no, you are the best person, whether GPA was executed by complainant. Because you have sold it to A2
number 2.
as a GPA holder. A2 in turn sold to A3 because A2 may not be knowing GPA. He is not directly to be considered. So A2 is subsequent purchaser, A3 is subsequent purchaser. They may not be involved. But what about you? You claim to be a GPA holder. Then the complainant has not executed a GPA. Then
The GPA also that is also cancelled.
see, GPA cancellation is subsequent. But by that time, deeds have been executed. Sale deed, gift deeds have taken place.
All the sale deeds also cancellation.
How they can be, sale deed can be cancelled, whether gift deed can be cancelled. There is no provision for cancellation of the gift deed. Sale deed, only reconveyance deed can be done. Sale deed cannot be cancelled except by the intervention of the civil court.
Civil court compromise sale deed was.
What about gift deed?
Cancel ಮಾಡ್ಕೊಂಡ್ರೆ 19/8/2022 ಎಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ out there ಮಾಡ್ಕೊಟ್ರು.
Out there ಮಾಡಿದ್ರೆ ಅಲ್ಲಿವರೆಗೆ the mental trauma that lady has gone, aged illiterate lady. ಯಾರ್ದೋ ಆಸ್ತಿ ಎಲ್ಲಮ್ಮನ ಜಾತ್ರೆ. ಏನ್ ಸರಿ, ಅವಳು ಇಲ್ಲಿಟ್ರೇಟ್ ತಂಬುದವಳು ಅಂತ ಹೇಳಿ ಅವಳು ಆಸ್ತಿನ ಹೊಡ್ಕೊಂಡು ಹೋದ್ರೆ 84 ಇರ್ರಿ 90 ಇರ್ರಿ, that is not the criteria. You, without there being a GPA, you created a GPA, impersonated the purchasers and executed a sale deed. ಈ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಇರ್ರಿ, ಬೇಕಾದವ್ರು ಇರ್ರಿ. ಅಥರೈಸ್ಡ್
ಎಲ್ಲರೂ ಸೇರಿ ಜೇಮ್ ಅವ್ರು ಯಾಕಂದ್ರೆ ವಯಸ್ಸಾಗಿತ್ತು
ಅವಳಿಗೆ ಅದಕ್ಕೆ GPA ಬೇಕ್ರಿ, ಸಾಯೋ ಹೆಣ್ಮಗಳಿಗೆ.
ಎಲ್ಲ ಕ್ರಿಯೇಟ್ ಮಾಡಿ ಚಾರ್ಜಸ್ ತಗೊಂಡಿರೋದು ಮಾಡಿ ಅವ್ರು ಸೇಲ್.
ನೀವು ಕಣ್ ಮುಚ್ಚೆ ನಿಮ್ ಹೆಸರಿಗೆ ಬಂದಲ್ಲಿ ಸಹಿ ಮಾಡ್ಕೊತ ಹೋದ್ರ ಮಲ್ವಿ ಸೇಲ್ ಡೀಡ್ ಹೇಗೆ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿದ್ರಿ? ಗಿಫ್ಟ್ ಡೀಡ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಬೇಕಾದ್ರೂ ಹೇಗೆ ಎಕ್ಸಿಕ್ಯೂಟ್ ಗಿಫ್ಟ್ ಡೀಡ್ ನೋಟ್ರಿ ಮುಂದೆ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಕ್ ಬರುತ್ತಾ? See, GPA is from in the name of the petitioner number 1 by the complainant. Howda? That is one aspect. The petitioner number 1 has executed the transactions, transfer. She is bedridden. How did she executed it? Without attending the sub-register office, how she could execute? Where is the compromise decree? Where is the compromise decree? Sale deed cancellation deed one day. Yeah, A2 and A4 have executed.
Jayamma, Sharadamma, and Sridhar. This is number 1, 2, and 3. 4 and 5 are the signature same.
Your deed disclosed the cancellation of the sale deed, but there is a gift also. Where is the gift deed cancellation?
And not to sell the party was.
Gift deed cancellation deed ellide. Because the transaction one sale deed agide, one gift deed agide. Sale deed cancellation deed ಬರ್ದು ಕೊಟ್ಟಿದ್ದೀರಿ. Where is the gift deed cancellation deed? ಅಥವಾ at least court decree declaring that the gift deed is null and void. According to you, the compromise was entered in December 21 in a civil suit. Then that decree should be prevailing. Ellida decree? That produce material.
Monday.
Tuesday, Mangalore.
No, hold on, yeah.
the direction flow from the sample code, I think the constitution to place the material information regarding the accused of being one arrested and awaited was raised. And basically, he was arrested on 28/6/2021.
But he was granted bail by the concerned court.
Trial court, A1, 437. The day he was arrested and produced 59.
Same day, ನಿಮ್ಗೂ ಅದೇ ಹೋಗಿ ನಾವೇನ್ ಬೇಡ ಅಂತೀವಿ.
ಅವತ್ತು ಕೊಟ್ಟಿದ್ದಾಗ I was remanded to custody. I was heard. Like I have a verified case, my lord. There is absolutely no incriminating material.
ಅಲ್ಲ, you are
Accused number 3. Accused number 3.
serial number 53.
Yes, my lord. I am representing accused number 3, my lord.
It is for anticipatory bail ಇದೆ.
Anticipatory bail in favor of accused number 2 by the coordinated bench, which also I want to place.
No, this petition is for anticipatory bail or regular bail. Then when you say that you are arrested.
No, your lordship asked. When was accused number 1 was arrested? When was he granted bail? The point to which the court was looking for was for 6 long or 7 long months after his release. What was the investigating officer doing in recording the statement or whatever? Which I will be placing it once again. I will read it.
You just argue, then
Yes.
recollect it.
Now, facts more vividly. My lord, this is a petition of 438, and this petition is arrived as accused number 3, Mohan Kumar. The brief facts that led to the registration of a case in FOC 8 of 2021 was in such a way that on 29/6/2021, the range forest officer Mudigere, on a credible information, he raids the house of accused number 1 Shivappa. They noticed accused number 1 Shivappa along with another accomplice of his, A2, were slicing the logs of a rosewood. Then on accused number 2 Lohit, on he immediately observing these officers coming to advancing towards him, he took to his heels, and later the accused number 1 was arrested the same day. He was produced, and his bail application was also moved the same day. On 30th, that is 4 days subsequent to filing of his bail application, he was enlarged on bail. And the further investigation taken up by the investigator, that is in reference to the entire case, they draw a master on that particular day, the place where that particular wood was seized, etc., etc. And further, for a statement was recorded. May I just take your lordship to the charge sheet, please, my lord. On the earlier occasion, I placed a charge sheet. May I just take your lordship? Running page number 6, my lord. But the original charge sheet it is mentioned as 7. The running page number 6 of the entire prosecution papers. Yes, it's a manuscript. My apologies. I could not get it type, but I can read out for your lordship with permission. Running page number 6 of the entire prosecution papers. Please,
Running page number 6 is only speaks regarding statement.
Yes, ma'am. ಹೇಳಿಕೆ ಅಂತಿದೆ. Accused number 1 ಹೇಳಿಕೆಯನ್ನ ಮಾಡ್ಕೊಂತಾರೆ. May I just read for your lordship?
ಯಾರ್ದು ಶಿವಪ್ಪನ?
Shivappa, accused number 1, the date on which he was arrested, 29/6/2021, his statement was recorded. I may be permitted.
28/6.
Yes, I may be permitted to read for your lordship. ಹೇಳಿಕೆ ಅಂತ ಇದೆ ಸ್ವಾಮಿ. I propose to underline that. Straight away to the facts of that particular statement. ದಿನಾಂಕ 28/6/2021 ಏನೆಂದರೆ, ಮೇಲ್ಕಂಡ ವಿಳಾಸದಾರಿಯಾದ ನಾನು ಈ ದಿವಸ ಅಂದರೆ ದಿನಾಂಕ 28/6/2021 ಮೂಡಿಗೆರೆ ವಲಯ ಅರಣ್ಯಾಧಿಕಾರಿಗಳು ಸಮಕ್ಷಮ ಹೇಳಿ ಬರೆಯಿಸಿಕೊಟ್ಟ ಸ್ವಇಚ್ಛಾ ಹೇಳಿಕೆ. ಇದು ಅವರ ವಾಲಂಟರಿ ಸ್ಟೇಟ್ಮೆಂಟ್. ದೋ ಇಟ್ ಇಸ್ ಕ್ಯಾಪ್ಷನ್ಡ್ ಆಸ್ ಹೇಳಿಕೆ, ಇಟ್ ಇಸ್ ಅನ್ ಅಡ್ಮಿಟೆಡ್ ಫ್ಯಾಕ್ಟ್, ಇಟ್ಸ್ ಸ್ವಇಚ್ಛಾ ಹೇಳಿಕೆ. ಈ ದಿವಸ ನಾನು ಮತ್ತು ನನ್ನೊಂದಿಗೆ ಲೋಹಿತ್ ಬಿನ್ ನಾಗರಾಜ್ ಇವರು ಸೇರಿ ನನ್ನ ವಾಸದ ಮನೆ ಹಿಂಭಾಗದ ತುಂಡು ಕಾಫಿ ತೋಟದಲ್ಲಿ ಈಕೆ ಮರದ ನಾಟುಗಳನ್ನು ಮರ ಕೊಯ್ಯುವ ಯಂತ್ರದಿಂದ ಸಹಾಯದಿಂದ ಸೈಜ್ಗಳನ್ನಾಗಿ ಪರಿವರ್ತಿಸುತ್ತಿರುವ ಸಮಯದಲ್ಲಿ ತಮ್ಮ ಇಲಾಖೆ ಸಿಬ್ಬಂದಿಯವರು ನನ್ನನ್ನು ಮರ ಬಿಟ್ಟ ಸಮೇತ ದಸ್ತಗಿರಿ ಮಾಡಿರುತ್ತಾರೆ. ಈ ಸಂಬಂಧ ನನ್ನ ಹೇಳಿಕೆ ಏನೆಂದರೆ, ಈ 4-5 ದಿನಗಳ ಹಿಂದೆ ಸಕಲೇಶ್ಪುರ ತಾಲೂಕು ಆನ್ಬಾಳ್ನಿಂದ ಒಂದು ಬೀಟೆ ಮರವನ್ನು ತಂದು ನನ್ನ ಮನೆಯ ಹಿಂಭಾಗದ ದಾಸ್ತಾನಲ್ಲಿಟ್ಟು, ಈ ದಿವಸ ಲೋಹಿತ್ ಬಿನ್ ನಾಗರಾಜ್ ಈತನನ್ನು ಕರೆಯಿಸಿ ಮರ ಕೊಯ್ಯುವ ಯಂತ್ರದಿಂದ ಸದರಿ ನಾಟನ್ನು ಕುಯ್ತ ಮಾಡಿ ಸೈಜುಗಳಾಗಿ ಪರಿವರ್ತಿಸುತ್ತಿದ್ದುದು ಸತ್ಯವಾಗಿರುತ್ತದೆ. ಓಡಿ ಹೋಗಿರುವ ಲೋಹಿತ್ ಬಿನ್ ನಾಗರಾಜ್ ಇವರು ಯಂತ್ರದ ಆಪರೇಟರ್ ಆಗಿದ್ದು, ಆತನ ಮರವನ್ನು ಕುಯ್ಯುತ್ತಿದ್ದು ನಾನು ಆತನಿಗೆ ಕುಯ್ತ ಮಾಡಲು ಸೂಚನೆ ಮತ್ತು ಸಹಕಾರ ತಿಳಿಯುತ್ತಿದ್ದು ಸತ್ಯವಾಗಿರುತ್ತದೆ. ಈ ಸಂಬಂಧ ನನ್ನ ಬಳಿ ಯಾವುದೇ ಇಲಾಖೆ ಪರವಾನಗಿ ಪಡೆದುಕೊಂಡಿರುವುದಿಲ್ಲ. ಈ ಸಂಬಂಧ ಇಲಾಖೆಯವರು ನನ್ನ ವಿರುದ್ಧ ಜರುಗಿಸುವ ಕಾನೂನು ಕ್ರಮಕ್ಕೆ ನಾನು ಬದ್ಧನಾಗಿರುತ್ತೇನೆ. ಇಷ್ಟೇ ನನ್ನ ಸ್ವಇಚ್ಛಾ ಹೇಳಿಕೆಯಾಗಿದ್ದು, ಓದಿಸಿ ಕೇಳಿ ಸರಿ ಇದೆ ಎಂದು ಒಪ್ಪಿ ಈ ಕೆಳಗೆ ಸಹಿ ಮಾಡಿದೆ. Based on this particular voluntary statement and also the immediate vicinity, they have registered a case against accused number 1 and 2. Accused number 3 was not arraigned as an accused, and the FIR restricted only in reference to accused 1 and 2 alone. Subsequently, my lords, accused number 2 approached this honorable court. He was granted a bail. May I advert your lordship today's document, the last document, wherein accused number 2 was granted bail by a coordinated bench. That is in criminal petition 5408 of 2021, dated 10th August 2021. So in reference to this accused number 2, the allegation was he was assisting accused number 1 in slicing that particular rosewood. So he was granted bail. That is one aspect. On he being granted bail, my lords, he was called upon to a notice. May I just advert your lordship for the document which I have placed today on record. May I just take the third document, my lords. This is a notice issued by the concerned officer. Certified copies I have placed, my lords. Notice anta ide. Page, my lords, the today's document, page 16 anta original lower court record 16 anta ide. Ivattu place madidane nanu numbering ಮಾಡಲಿಲ್ಲ, ಕ್ಷಮಿಸಬೇಕು. Notice dated 6/1/2021. Today with a memo I have placed. My lordship is within the entire prosecution period. The documents which are placed tomorrow, my lord. Today, my lord. Most of them. Yes, ma'am. The third document, notice. At the outset, I may be permitted to point out one thing. Wrongly or inadvertently, the investigator has mentioned 16/1/2021 is the date on which this notice was made. Strictly speaking, this
6/1/21.
6/1/2021 ಆಗಲೇ ಇಲ್ಲ, offense ಆಗಿರಲಿಲ್ಲ. It might be a clerical error or default. So this notice was caused on accused 1 and 2, calling upon them to make a statement. Your lordship, I may be permitted to read your lordship constitution. ಈ ಮೂಲಕ ನಿಮಗೆ ತಿಳಿಯಪಡಿಸುವುದೇನೆಂದರೆ, ನೀವು ಕಾನೂನು ಬಾಹಿರವಾಗಿ ಮೂಡಿಗೆರೆ ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಮೂಡಿಗೆರೆ ಗ್ರಾಮದ ಹಳೆ ಮೂಡಿಗೆರೆಯಲ್ಲಿ 2 ಬೀಟೆ ಜಾತಿಯ ಮರಗಳನ್ನು ಕಡಿತಲೆ ಮಾಡಿರುವುದರಿಂದ ನಿಮ್ಮ ವಿರುದ್ಧ ಅರಣ್ಯ ಮೊಕದ್ದಮೆ 8/2021/22 ದಾಖಲು ಮಾಡಲಾಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಸದರಿ ಮೊಕದ್ದಮೆ ಇತ್ಯರ್ಥದ ಬಗ್ಗೆ ದಿನಾಂಕ 21/1/2022 ಬೆಳಗ್ಗೆ 3 ಗಂಟೆಗೆ ಸರಿಯಾಗಿ ಈ ಕಚೇರಿಗೆ ಹಾಜರಾಗಿ ಕೆಳ ಸಹಿದಾರರಾದ ಸಮಕ್ಷ ನಿಮ್ಮ ಹೇಳಿಕೆಯನ್ನು ನೀಡುವಂತೆ ತಿಳಿಸಿದೆ. ಹೇಳಿಕೆಯನ್ನು ತಿಳಿಸುತ್ತದೆ. ಇದಕ್ಕೆ ತಪ್ಪಿದ್ದಲ್ಲಿ, ದಿಸ್ ಇಸ್ ಅನದರ್ ಇಂಪಾರ್ಟೆಂಟ್ ರೈಟರ್ ದೇ, ಇದಕ್ಕೆ ತಪ್ಪಿದ್ದಲ್ಲಿ ನಿಮ್ಮ ಹೇಳಿಕೆ ಏನು ಇಲ್ಲವೆಂದು ಭಾವಿಸಿ ನಿಮ್ಮ ಮೇಲೆ ಅರಣ್ಯ ದೋಷಾರೋಪಣ ಪಟ್ಟಿಯನ್ನು ಸಲ್ಲಿಸಲಾಗುವುದು. ಇದಕ್ಕೆ ಅವಕಾಶ ಕೊಡದಂತೆ ನಿಗದಿತ ದಿನಾಂಕದಂದು ಹಾಜರಾಗಿ ಪ್ರಕರಣವನ್ನು ಇತ್ಯರ್ಥಪಡಿಸಿಕೊಳ್ಳಲು ಈ ಮೂಲಕ ತಿಳಿಸಿ. The point to which I propose to point out here in this document is the investigator, despite the fact that accused number 1 has already made his voluntary statement, and though it is captioned as ಹೇಳಿಕೆ,
ಆ ಒಕ್ಕಣದಲ್ಲಿ ಬರುವಾಗ ಸ್ವಇಚ್ಛಾ ಹೇಳಿಕೆ ಅಂತಕ್ಕಂಥದ್ದು ನಮೂದಾಗಿದೆ, ಒಪ್ಕೊಳ್ತೀನಿ ಸ್ವಇಚ್ಛಾ ಹೇಳಿಕೆ. ನೀವು ಮತ್ತೆ ಒಂದ್ಸಗಿ ಹೇಳಿಕೆಯನ್ನೇ ನೀವು ಮತ್ತೆ ಅದನ್ನು ತಗೊಳ್ತಾ ಇರ್ತಕ್ಕಂಥದ್ದು ಆಫ್ಟರ್ ಲ್ಯಾಪ್ಸ್ ಆಫ್ 7 months of he being released on bail. This was the point to which your lordship was pleased to direct the prosecution to call upon to place that on record. Anyway, I have placed it. Now, may I just advert your lordship to the statement that was recorded in pursuance of that particular notice. Just with the lordship to statement at running page 7 in the entire prosecution case. Shivappa. Running page 7, my lord.
Numbering ಇಲ್ಲ.
ಮಾಡಿದ್ದೀನಿ. Oh, I'm sorry.
Original petition numbering ಇಲ್ಲ. That is additional document dated 7/11.
Earlier to at least the entire prosecution and papers.
26/9, 7/11. In 26/9 documents, no numbering, no documents, except the order of the concerned court with the list of the charge sheet.
My lord, my lord.
But in
My lord.
subsequent documents dated 7/11, there is a statement said to have been given by Shivappa
Very good.
dated 21/1/22.
My lord, exactly. That's the document to which I'm advocating your lordship. May I just brief for your lordship? ಏನಂದ್ರೆ ದಿನಾಂಕ 28/6/2021 ದಾಖಲಿಸಿರುವ ಮೊಕದ್ದಮ ಸಂಖ್ಯೆ 8/2021/22 ಬಗ್ಗೆ ವಿಷಯವನ್ನು ನಾನು ತಿಳಿದುಕೊಂಡಿರ್ತೇನೆ. ಈ ಬಗ್ಗೆ ನಾನು ಹೇಳುವುದೇನೆಂದರೆ ದಿನಾಂಕ 28/6/2021 ನಾನು ಮತ್ತು ನನ್ನೊಂದಿಗೆ ರೋಹಿತ್ ಅಲಿಯಾಸ್ ಇಬ್ಬರು ಸೇರಿ the same statement what we made the previous time. ವಾಸದ ಮನೆ ಹಿಂಭಾಗದ ಕಾಫಿ ತೋಟದಲ್ಲಿ ಏಕೆಂದ್ರೆ ದುಂಡು ನಾಟುಗಳನ್ನು ಮರ ಬೆಳೆಯುತ್ತಿದ್ದ ಯಂತ್ರ ಸಹಾಯದಿಂದ ಸೈಜುಗಳನ್ನಾಗಿ ಪರಿವರ್ತಿಸುವ ಸಮಯದಲ್ಲಿ ನಮ್ಮ ಇಲಾಖೆಯ ಸಿಬ್ಬಂದಿಯವರು ನನ್ನನ್ನು ಮತ್ತು ಮರಮುಟ್ಟು ಸಮೇತ ದಸ್ತಗಿರಿ ಮಾಡಿರುತ್ತಾರೆ. ಈ ಸಂಬಂಧ ನನ್ನ ಹೇಳಿಕೆ ಏನೆಂದರೆ ಏಕೆ ಮರದ ನನ್ನ ಮನೆ ಹಿಂಭಾಗ ದಾಸ್ತಾನಿಟ್ಟು ಈ ದಿವಸ ಲೋಹಿತ್ ಬಿನ್ ನಾಗರಾಜ್ ಈತನನ್ನು ಕರೆಯಿಸಿ ಹೊರಕೊಯ್ಯುವ ಯಂತ್ರ ಚಾಲಿತ ಬೆರಗಸದಿಂದ ಸದರಿ ನಾಟನ್ನು ಕೊಯ್ತು ಮಾಡಿ ಸೈಜುಗಳನ್ನಾಗಿ ಪರಿವರ್ತಿಸುತ್ತೇವೆ. ಲೋಹಿತ್ ಅಲಿಯಾಸ್ ಶಂಕರ್ MS ಇವರು ಯಂತ್ರದ ಆಪರೇಟರ್ ಆಗಿದ್ದು ಆತನು ಮರವನ್ನು ಕುಯ್ಯುತ್ತಿದ್ದು ನಾನು ಆತನಿಗೆ ಕೊಯ್ತ ಮಾಡಲು ಸೂಚನೆ ಮತ್ತು ಸಹಕಾರ ನೀಡುತ್ತಿದ್ದು ಸತ್ಯವಾಗಿದೆ. ಸದರಿ ಮರವನ್ನು ದಿಸ್ ಇಸ್ ಇಂಪಾರ್ಟೆಂಟ್ ಮೈ ಲಾರ್ಡ್, ಸದರಿ ಮರವನ್ನು ಸಕಲೇಶ್ಪುರ ತಾಲೂಕಿನ ಆನಬಾಳು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 108/1 ಒಂದು ಖಾತೆದಾರರಾದ HJ ಮೋಹನ್ ಗುದ್ದೇಗೌಡ ಅವರ ಹಿಡುವಳಿ ಜಮೀನಿನಲ್ಲಿ ಸದರಿ ಖಾತೆದಾರರಿಗೆ ಹಣವನ್ನು ಕೊಟ್ಟು ಸದರಿ ಬೀಟೆ ಮರವನ್ನು ಕುಯ್ದು ತಂದಿರುತ್ತೇನೆ. ಈ ಸಂಬಂಧ ನನ್ನ ಬಳಿ ಯಾವುದೇ ಇಲಾಖೆ ಪರವಾನಗಿ ಕೊಟ್ಟಿಲ್ಲ. The same reiteration, except an additional fact emerging there was that this petitioner herein arrived as accused number 3. He has given that particular tree which was comprised in survey number 108. May now just take a lordship to the document of the prosecution itself, wherein they have placed a what do you call it, survey or what you call one satellite survey at running page 17. Running page 17 in the same set of documents of the prosecution. Wherein I just propose to point out, my lords, stump spot, Anbal village, survey number 97. I'll repeat, stump spot, Anbal village, survey number 97. ಇದು ಅವರೇ ಹಾಜರುಪಡಿಸಿರ್ತಕ್ಕಂಥ ದಾಖಲೆ. ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಕೇಸು ಆ ಸ್ಟೇಟ್ಮೆಂಟ್ ದಟ್ ಇಸ್ ಬಿನ್ ರೆಕಾರ್ಡೆಡ್ ಅದು ಸ್ವಇಚ್ಛಾ ಹೇಳಿಕೆ ಅಂತ ಖಂಡಿತ ಅಲ್ಲ, ಅದು ಹೇಳಿಕೆ ಅದು ಆ ಆಸ್ಪೆಕ್ಟ್ ಆಮೇಲೆ ಬರ್ತೀನಿ ಸರ್. Now, my land is 108, where the same respondent, complaint police have already marked as one of the document, placed one of the document. My RTC is placed on that. It is 108.
Yes.
So the question of connecting the petitioner based on the statement, which is totally inadmissible, because it's a statement under 161. which is totally inadmissible and he cannot speak against me. And coupled with that, when the GPS survey photograph disclosed the fact that the stump is located in survey number 97, and the same police placing my RTC and also in the Maser that the stump was found in survey number 108. So there is a question of connecting this person to that. Is the sole point which I propose to point out. Furthermore, at the cost of repetition, I propose to tell the statement which I read for your lordship's consideration dated 21/1/2022. Is it to be now looked into under what clause? That is one aspect. Can an accused speaks a fact incriminating against him? Now, with all probability, this is to be now looked into. The statement is recorded on 161. And when a statement is recorded by an accused, he cannot be cited, and in the entire prosecution papers, he is not been cited as a witness, he is cited as an accused. He cannot speak about that. What is the now, who is the witness who is going to speak against me is the point for the case. So, my lords, coupled with this, the last point I propose to canvass, my lords, the accused number 2, my lords, he's been granted bail by the government credits, and his involvement is slightly at the higher side of the edge, where I was physically, accused number 2 was physically present in slicing the prisoner. My road, I mean, in itself, it is not possible, with all probability, it could not be taken on record because for the reason that it is a statement there, and there is none to speak against me, and accused number 1 cannot speak to that particular fact in the court of law. There is absolutely no material collected against me to implement that register. And that to this statement of the one which I read to your lordship consideration dated 21/1/2022, it is recorded 7 months of his being released. So with these submissions of mine, the petitioner is on better footing to be sought for a relief as made out in the application. Any stringent conditions may be imposed. I pray on the court to allow this particular petition to be released.
He has harped one point. He is the owner of which land? He is owner of which land? ಅಷ್ಟೇ ಕೇಳಿದ್ ನಿಮಗೆ ನಾನು. ನಿಮ್ ಕೇಸ್ ಪ್ರಕಾರ 108/1. Then in the map, why you have shown the stump spot as survey number 97? Do you say that survey number 97 belongs to him? But 108 you are not shown in your map. Then why one you have shown it as 97? Okay, let us accept it, whether it is 97 or not. Have you drawn a measure at survey number 108 or survey number 97? When it was drawn?
(21/1/2022), my lords. That is the date on which the second statement was recorded. On accused number 1 showing the spot. Accused number 1 instance ಅಲ್ಲಿ ತೋರಿಸಿರ್ತಕ್ಕಂಥ spot ನಲ್ಲಿ ಆ ಮಾಜರ್ ಡ್ರಾ ಮಾಡ್ತಾರೆ, which is once again survey number 97. not 108. But the content of that particular Maser says 108. And incidentally, my lords, another interesting point here. ಆ ಮಹಾಜರ್ಗೆ ಒಂದು ಶರ ಬರೀತಾರೆ. I just read for once. ಅದು page 10, running page 10 ಅಲ್ಲಿ my lords. I just read for once. ಸ್ಥಳ ಮಹಾಜರ್ running page 10 my lord. ಪಂಚಾಯತ್ದಾರರ ಸಹಿ ಸ್ಥಳ ಮಹಾಜರ್ ಜರುಗಿಸಿದಾಗ ಅಕ್ಕಪಕ್ಕದ ಮನೆಯವರು ಇದು ಮನೆ ಹತ್ರ ಸ್ಪಾಟ್ ಮಾಡಿ. Coming to this ಮಹಾಜರ್ drawn at place survey number 108. ಅದಕ್ಕೂ ಕೂಡ ಯಾರು ಇಂಡಿಪೆಂಡೆಂಟ್ ವಿಟ್ನೆಸ್ ಇಲ್ಲ. ಎಲ್ಲರೂ ಗವರ್ಮೆಂಟ್ ಅಫಿಷಿಯಲ್ಸ್, ಫಾರೆಸ್ಟ್ ಅಫಿಷಿಯಲ್ಸ್.
Yes. At whose instance this Maser was drawn? At whose instance this Maser was drawn?
Number 1.
Wait, have patience. At whose instance the Maser was drawn? Even at instance of A1 Maser was drawn. Okay, na? Whether his signature was there on the Maser? Why is not why his signature was not obtained on the Maser for having led to this spot and shown this spot? That was not there. Basic salary, huh? Serious lapse, doubting entire case of the prosecution agalva. Okay, you endorse that no panchas, local panchas did not venture to act as a panchas, local persons ಅಂತ ಹೇಳಿ endorsement ಮಾಡಿದ್ರಿ. ಹೌದಾ? In that event, what was the normal thing? Your officials could have acted as a panchas by passing the certificate to that effect. That was also not done. Because normally if nobody is there, ನಿಮ್ಮ ಅರಣ್ಯ ಫಾರೆಸ್ಟ್ ಗಾರ್ಡ್ಸ್ ಪಂಚಾಸ್ ಅಂತ ಹೇಳಿ ಟ್ರೀಟ್ ಮಾಡ್ತೀರಿ, ಅವ್ರನ್ನ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತೀರಿ, ಪುಟ್ ಸರ್ಟಿಫಿಕೇಟ್. Nobody was prepared. Okay, fine. At least then they will be subjected to cross examination. Genuineness can be ascertained. ಇಲ್ಲ ಅದು ಇಲ್ಲ. Then how can you call it as a Maser? What is the base for treating it as a Maser? ಎಷ್ಟು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಡಿಸಿಷನ್ಸ್ ಬಂದಿದಾವ, ಹೈಕೋರ್ಟ್ ಡಿಸಿಷನ್ಸ್ ಇದಾವೆ. ಯಾವ ರೀತಿ ಮಜರ್ ಮಾಡಬೇಕು, ಫಾರೆಸ್ಟ್ ಆಕ್ಟ್ ಕೆಳಗೆ ಯಾವ ರೀತಿ ಮಜರ್ ಫಾಲೋ ಮಾಡಬೇಕು, ವಾಟ್ ಆರ್ ದಿ ಪ್ರೊಸೀಜರ್ ಟು ಬಿ ಅಡಾಪ್ಟೆಡ್ ಅಂಡರ್ ಸೆಕ್ಷನ್ 62 ಆಫ್ ದಿ ಕರ್ನಾಟಕ ಫಾರೆಸ್ಟ್ ಆಕ್ಟ್. ಒಂದಾದ್ರೂ ಸರಿಯಾಗಿ ಫಾಲೋ ಮಾಡ್ತಾರ ಇವರು? ನಿಮ್ 90% ಕೇಸ್ ಫೇಲ್ ಆಗುದಿಲ್ಲ. ಇದು ನಿಮಗೂ ಗೊತ್ತಿದೆ, ಫಾರೆಸ್ಟ್ ಆಫೀಸರ್ಸ್ಗೂ ಗೊತ್ತಿದೆ. ಆದ್ರೂ ಯಥಾಸ್ಥಿತಿ ಅದೇ. And ಇನ್ನೊಂದು, one interesting issue he has raised. How you record 161 statement of the accused?
Can you be second? Can you speak something?
Voluntary statement can be recorded once. Custody record ಮಾಡಿದ್ರಿ. ನನ್ನ ಹಿತ್ತಲ್ದಾಗ ಸ್ಟಾಕ್ ಮಾಡಿದ್ದು ನಾನು ಕೊಯ್ತಾ ಇದ್ದೆ ಬಂದ್ರ 6 ತಿಂಗಳ ನಂತರ ಮತ್ತೆ ಅವ್ನು ಕರೆಸಿ ಅವ್ನು ಸ್ಟೇಟ್ಮೆಂಟ್ ತಗೊಳ್ತಿದ್ದ. Wonder which provision of law? And you never say that it is a voluntary statement. You say that it is a statement. Further voluntary statement. Just confession statement hage.
173 it is again. Any number of
And ಇನ್ನೊಂದು ಕೇಳ್ತೀನಿ, whether confession statement, the forest officers are not the police officers. Whether the confession statement before the forest officers is admissible in evidence out of the records. I am no way concerned with this case. It is in general. Because there is a citation that the railway protection force, they cannot be treated as a police officers, and confession statement given before the under RPUP Act, before the RPF is admissible. It is not hit by section 20. Whether it is applicable? Because normally they are not treated as police officers, but I think I have not come across that they cannot be treated as a police officers until ಇಲ್ಲಿವರೆಗೆ ಯಾವುದು citation ನಾನು ನೋಡಿಲ್ಲ. So the presumption is that they are to be treated as regards this, they should be treated as a police officer. That should be the presumption, but I want to get myself enlightened. ಆ ಉದ್ದೇಶದಿಂದ ಅಷ್ಟೇ ಕೇಳಿದ್ದೆ ನಾನು.
When the word in the top of the statement, second statement, ಹೇಳಿಕೆ ಅಂತಕ್ಕಂಥ ಒಂದು ಶಬ್ದ ಒಂದು. ಆಮೇಲೆ all the my senior SPP here can also assist.
ಅದೇ ನಾನು ಕೇಳ್ತೀನಿ. Not in respect of this case.
Series of judgments, including the latest one, in the context of the SCS Act of 2000, they have to be given with that.
But ಒಳ್ಳೆದಾಗ because
Due respect to
I don't know for that.
because ultimately we'll have to enlighten ourselves. Because all government officers now treat themselves as a police officer. There can be no doubt certain rights, the certain duties, certain powers were granted. Whether while recording a confessional statement, whether they should be treated as a police officers. If they are treated as a police officer, the confession statement goes out. If they are not treated as a police officers, then confession statement becomes admissible, as in case of customs and other. Customs, they are not to be treated as a police officers. Police officers, yes.
it is admissible there. It is admissible there.
ಅಲ್ಲ ಅದನ್ನೇ ಹೇಳಿದ್ವಿ, because there is a specific citation that they are not to be treated as a police officer.
That in mind, who will say, 3 or 4 years. The context of NDPS, whether it is stated there before an authority there can be admissible, that also is there. That compilation I made it. I will
Quote ಮಾಡಿ, you'll get it. Huh?
Another point here, with adding to my senior's submission. Let us presume that for a moment, let us presume that the officer consent.
See, I'm not concerned.
No, one second.
I know it.
No, one
Even
second.
if they are treated as an officer, then it is hit. Even otherwise, if it is admissible, the consequences will
Yes.
have to be considered. That is a different. I'm not. I'm
There-
not talking. I'm only wanted to ascertain
There I
the position of the forest officers.
There I propose to write section 161 subsection 2. There again, my senior will have to stand in concurrence with me or in agreement with me. Section 161 subsection 2 never permits an investigator, keeping aside your
It
lordship.
shall not be signed. That's all. No statement
No, that's
made before the
subsection-
police
No,
officer
that's
shall be.
subsection 3, my lord. One subsection 161 subsection 2. I will be for a second. Wherein such person, this is 161 subsection 2. Such person shall be bound to answer truly all questions relating to such case put to him by such officer, other than question, the answers to which would have a
Incrementing against him, he is not supposed to. If the incrementing evidence comes there,
Yes.
it becomes a confession
Yes.
statement automatically.
Yes,
It doesn't fall under the category
Yes.
of 161.
yes. And coming to the case on hand, my lords, he has recorded a statement on.
Yes. ಈ ಕೇಸ್ಗೆ ಅದು ಈಗ ಇದು ಕೇಳಿದ ಡಿಸ್ಕಷನ್ ಅದರ್ವೈಸ್ ಟು ಇಂಪ್ರೂವ್ ಅವರ್ ನಾಲೆಜ್ ಅಷ್ಟೇ, ಅದು ಬೇರೆ ಏನಿಲ್ಲ. ಅದು ಈ ಕೇಸ್ಗೆ ಏನು ಹೇಳ್ತೀರಾ? There cannot be two confession statements. If it is 161 statement, it cannot be signed. Okay, fine. And a statement under 161 cannot be given by an accuser. Accuser. And there cannot be two confession statements. It is not your case that it is a further confession statement. One eddo. Here one eddo. The Mahazar disclosed that the person who has led has not even signed. The Mahazar is not signed by any of the Mahazar Panchas.
It is recorded by a, who is not a police. That the principals let down under the question.
Again, I'm saying that is a different aspect. Then even let us accept your contention. Then it should be a confession statement.
The statement rendered.
Okay. Then why the same forest officer earlier recorded a confession statement without recording only statement?
The word.
There are two confession statements. One is specifically says that confession statement. Subsequently, he says that only statement. After lapse of say more than 6 months.
7 months.
Could be a further statement at the moment. It would be a further.
I don't stand in agreement.
Okay, let us accept a measure was drawn on the basis of a further statement. No panchas. Even the person who has led, even he didn't sign.
I will not get. But as a principle, if there is a statement and he is not a police officer, who does it give?
ಅಲ್ಲ ಅದಕ್ಕೆ ನಾನು ಕೇಳಿದ್ದು ನಿಮಗೆ whether a forest officer falls under this.
No, he will not be a police officer. I will justify it.
Yeah, I want to know it because not in this case. In this case, it may be irrelevant. Yes, that regularly these matters will come. So therefore, I wanted to ascertain with that. Yes, anything else? Even who has given statement did not sign, who led to this spot did not sign it. The merger also does not bear the signature of the panchas. Merger was drawn at one place. Sketch was shown to be at another place.
Their own document. GPS says that it is 197, not 108. And artist placed by the same investigator.
Sorry. The petitioner has filed the petition under section.
I don't mind.
ತಪ್ಪಾಗತ್ತೆ ಸ್ವಾಮಿ, ನಾನು ನಿಮ್ಮ ಕನ್ಫೆಷನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅದ್ರ ಮೇಲೆ ಏನು ಫೈಂಡಿಂಗ್ ಕೊಡ್ತಾ ಇಲ್ಲ. ಡೋಂಟ್ ವರಿ. I am not going to give any finding regarding whether it is to be treated as a confession statement. That he has also said that he will enlighten the court because it may be relevant in other matters also. That will be different. I am concentrating on merits. The conduct of the investigating agency, long gap, person who leads for drawing the measure, not signing. No pansa has been there quoted. The officers getting the measure done themselves without referring that pansas are present. Iವೆಲ್ಲ issues ಇದು ಅಷ್ಟೇ. I'm not going to give and variation in the survey number as per your own case. As per your own case, showing one survey number at one place and another survey number at another place. Petitioner, accused number 3 has filed this petition seeking anticipatory bail in the event of his arrest in associate of Puligere police station. Registration of the offences, punishment and so on. For the learned counsel for petitioner and learned CGP for respondent state, there is the reports. The brief factual matrix leading to the case are that on 28/6/21, the small forest officials received credible information that some persons are cutting the rosewood log behind the house of number 1, who is resident of Podgere. Then they went to this spot and found that the accused number 1 and 2 cutting the rosewood log. The accused number 2 fled from this spot and accused number 1 apprehended there, and they have also recovered 2 rosewood logs with it was beating and 10 bullets. The confession, then on interrogation, a measure was also drawn and crime came to be registered. In the meanwhile, the accused number 1 was interrogated and his confession, his statement was recorded, wherein he has given a statement asserting that the logs were lying in his behind his house, and that the logs were stored by him, and with the assistance of accused number 2, he was converting them into billets. On the basis of this statement, the A2 was also implicated. Interestingly, subsequently, this statement was said to be recorded on 28/6/21 itself. However, subsequently, a notice came to be issued to accused number 1, who was subsequently enlarged on bail by the concerned magistrate. And again, his presence was secured on again another notice Another notice came to be issued on 6/1/22 to accused number 1 and 2 for their appearance on 21/1/22 for giving further statement. The further statement came to be recorded on 21/1/22, wherein it is asserted that the Rosewood BT log was grown in survey number 108/1 owned by present petitioner accused number 3, and same was purchased by the present by accused number 1, and he brought it without obtaining any prior permission and was found converting it into billets. On the basis of this subsequent statement dated 21/1/22, the present petitioner is implicated as accused number 3. It is specifically asserted that the rosewood tree was grown in survey number 108/1 belonging to the present petitioner. Next, apprehending his arrest, the petitioner has approached the learned session judge and his bail petition came to be rejected. Hence, petitioner is before this court. Having heard the arguments and perusing the records, it is evident that the petitioner is admittedly owner of survey number 108/1. All along, it is specifically asserted by the prosecution that the BT was uprooted from survey number 108/1 belonging to the present petitioner, and same was purchased by the accused number 1. But quite contrarily, in the Google sketch produced by the prosecution itself, the stump spot is shown to be survey number 97. When the prosecution specifically asserts that this stump spot is survey number 108/1, but a quite contrary is shown in the sketch, showing it as survey number 96. There is no explanation from the prosecution in this regard. Next. Even it is asserted that merger was also conducted in survey number 108/1. But on perusal of this merger, it is evident that it is not signed by any of the panchas. As per the case of the prosecution, the merger was drawn at the instance of the accused number 1, but on perusal of the said merger, his signature is also not found on the merger. There is no explanation to any of these aspects by the prosecution. Hence, the prosecution itself is not certain as to what is the allegations regarding cutting of the BT tree and exact location from where it was cut. Next. Further, it is also evident that the accused number 2, who was found assisting the petition accused number 1 in converting the billets converting the tree into billets, was enlarged by this court in criminal petition number 5408 of 21 by this coordinate bench of this court by the order dated 10th August 21. The present petitioner is standing on a better footing compared to the accused number 2. looking to these facts and circumstances and conduct of the prosecution and uncertainty prevailing in the case of the prosecution, in my considered opinion, petitioner can be admitted on and interpreted to do. The other apprehensions raised by the learned HCCP can be moved about confusion. Hence, the petition needs to be allowed and accordingly I proceed to pass the time. Saying 2 lakhs. You are for
For the petition,
petition for bail, huh?
the 439 regular.
Have you got any right to object to a application filed by the impleader? Out of records, none in here discussion is okay, that is a different. Strictly legally speaking, whether you have got any right to oppose the application. It is between the court and the complainant or victim, whatever it may be. He is seeking the leave of the court. It is the discretion of the court either to grant permission or to reject. That is one aspect. Is it necessary to hear you? It is my question. Just at academic, regularly ಬರ್ತಾ ಇದಾವೆ ಈಗ.
My limited knowledge,
Limited knowledge ಅನ್ಬೇಡ್ರಿ, ಗೊತ್ತಿರಲ್ಲ ಎಲ್ಲೆಲ್ಲಿ knowledge. Knowledge is not a property of anybody.
intent of the legislature for inserting 24 clause 8, 301 and 302 was only to give the victims counsel an assisting role.
That is not a criteria.
Whereas the IA which has been filed by the, as your lordship rightly pointed out yesterday, there is an overt act that seeking to impede themselves and try to be a.
That is correct. I can understand your apprehension. I can understand. In CRPC, there is no provision for impleading. Impleadment is unknown to CRPC. Correct? I may be wrong. Enlighten me if I am wrong. And now, court is also learning every day. Because every time new concept will be canvassed before the court from various angles. A new entrant will give a new dimension to a question. Who knows from what angle? Only thing is we should be receptive. That is the only issue. If we are not receptive, matter ends there. The issue is yesterday only he has clarified.
I even cited one judgment of the Honorable Appellate Court. Put in 2022 SCC 470. Very well, got to the same question, but the question therein was not with respect to the hearing of a bail application, whereas it was pertaining to the trial, where an application was filed by the victim counsel to lead evidence and to argument.
See, all the matters are pertaining to even 301, 2, they are pertaining to 302 especially. It is only implication starts from the trial only. But 301, yes, during the course of inquiry, and what do you use Madidarale? During course of inquiry includes everything then. Once inquiry word is used, it will become a vast. But if the word is used at trial, it restricts, correct? And now, all matters are pertaining to trial only. The only latest, the famous case that was considered only in respect of a bail petition. Earlier, all matters, some observations during the course of the recording the reasoning, some observations will be there. But that case, particular case was pertaining to bail only. On merits and the trial entirely different aspects. Yes, you want to add something? You can, because
See, their contention is that, that's a if the acquisition of very empty, see, everyone will be released on bail.
see, yesterday only on this point a discussion has taken. That is a difference. Because when it is a question of cancellation of bail, when he is opposing, when he want to contest, he should know his limitations. And there are different versions. Informant, victim, aggrieved person, they are not one and the same. Complainant, you complainant and informant may be one and the same. The complainant may be the aggrieved person, but all aggrieved persons are not complainants. Because there was that issue has arose because a division bench of I think Orissa taken a counter review. The apex court has made it very clear. All aggrieved persons are not the complainants. Yes, Ian Madanante. Our kidnap, the allegation is very specific. He is an aggrieved person in any event. He is an aggrieved person. He is the complainant and he is the aggrieved person in this case. He is one and the same.
As a matter of right, because the public prosecutor is already present, and there is even for the selection of the public prosecutor, there are certain criteria. Then, hence, I don't feel at this juncture, at this stage, their presence is required because allowing such a practice will become a vindictive practice. And it will lower the status of public prosecutors.
Correct, sir. Court may accept your argument, but when the apex court says,
even I have cited the recent 2020.
Your 2020 case is pertaining to trial. And the 2022, what he is relying is also a full bench petition of the Supreme Court directly on the point of bail only. It is restricted to bail only, and that was the famous case.
He may be permitted to represent only to the extent of assisting the prosecution rather than affording him an opportunity of argument. It's my humble submission.
Why? Why that should be restricted? If they are permitted to argue the matter, what harm is going to cost you? Because here, that your argument would have been 100% would be acceptable if he is only an informant, having no better knowledge, he could have assisted. Here he is a victim but complainant. He suffered, he was kidnapped. There was certain demand and other things. Those are the merits. That is a different aspect. But he is a victim of the crime. And the apex court says that victim of the crime, the interest of the victim of the crime cannot be compromised in his absence without giving him an opportunity if he comes voluntarily. Because in case of victim of crime regarding 376, a specific provision has been made under 439 subclause 2. Isn't it? Because there is victim of crime or the minor guardian is mandatorily necessary party. But in other matters, that is not the case. But the apex court says when a victim of crime voluntarily appears, he should be heard. He should be given an opportunity to contest the matter. Citation Korea the name is. Idena? ನೀವು ಯಾವ್ದು ರಿಲೈ ಮಾಡಿದ್ರಿ
2022.
ಎಲ್ಲಿದೆ?
It's long.
Statement of objections. Including statement of objections post ಆಗಿದೆ.
ಈಗ ಗೊತ್ತಿದೆ.
ನಮ್ಮ ಹತ್ರ ಇನ್ನ ಬಂದೇ ಇಲ್ಲ ನಿಮ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ನಡ್ಕೊಂಡು ಬರ್ಬೇಕಾದ್ರೆ ಟೈಮ್ ತಗೊಳ್ತದ ಅದು ಈಗ ಕೊಟ್ಟಿದ್ದೀರಾ This is the 2-bench edition. This is the full bench edition. Law precedents. Simple law precedents. ಯಾವ್ದು ಅಪ್ಲೈ ಆಗುತ್ತೆ
ಅಕಾಡೆಮಿಕ್ ಪರ್ಪಸ್ ಆಯ್ತು
ಹೇಳಿ ನೋಡೋಣ ಕೇಳೋಣ ಮತ್ತೆ ಅಕಾಡೆಮಿಕ್ ಪರ್ಪಸ್ ನೀವು ಡಿಸ್ಕಷನ್ ಮಾಡ್ತೀನಿ ಅಂದ್ರೆ ಐ ವಿಲ್ ಬಿ ಹ್ಯಾಪಿ ಹೇಳಿ I've gone through this decision they have discussed the role of the public prosecutor, the assistant public prosecutors, intention of the legislation, what will be the consequences. This is also I have referred it. But this Apex Court full bench edition. ಇದಕ್ಕೆ ಏನ್ ಮಾಡ್ತೀರಾ council or applicants and the learned counsel for petition. You want to add something, anything? ನಿಮ್ಮ ರೋಲು ಪೂರ್ಣ ಸ್ಟಬ್ ಮಾಡ್ತಾರೆ ಇಷ್ಟೇ ಮೊದಲೇ ನಿಮ್ ಗಮನಕ್ಕೆ your identity will be completely that was in fact the observation of the division bench edition of the Apex Court. Public prosecutor role will be minimized. No, though he is statutory recognized, ಬೆಲೆ ಇಲ್ಲ ಆಗುತ್ತೆ ಅನ್ನೋ ಒಂದು ಉದ್ದೇಶದಿಂದ that observation has made division bench. But subsequently Apex Court, the right of the victim stands on higher pedestal ಅಂತ ಅವ್ರು ಹೋದ್ರು. ಅದಕ್ಕೆ ನಿಮ್ನ ಕೇಳೋದು ನನ್ನ ಕರ್ತವ್ಯ ಅಂತ ಹೇಳಿ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. He doesn't fall under section 301 part 2. Basically concept wrong ಇದೆ ಅವರು 301 sub clause 1 ಕೆಳಗೆ ಅಲಾವ್ ಆದ್ರೆ 301 2 ಕೆಳಗೆ ಬರ್ತಾರೆ ಅವರು. ಇನ್ನದ ಅವ್ರದ್ದು ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲ ಅವರು ಆಲ್ರೆಡಿ he has presumed that he has brought on record he has got every right. ಅದು ಬರಲ್ಲ ಅವ್ರಿಗೆ. ಹೀಗೆ wrong provision of law is quoted, but quoting of wrong provision of law does not end in rejection of the application. Correct? Now it is also settled law. ಎಲ್ಲ ಕೋರ್ಟ್ನವರ ಮಾಡ್ರಿ ಅಂತ ಇಂಡೈರೆಕ್ಟ್ಲಿ ಹೇಳಿದೆ. I told you, HGP on I number 1 of 22. I number 1 of 22 is filed by the applicant under section 302 subclause 2 of CRPC for impleading him as respondent number 2 so as to contest the matter. He claims that he is the victim of the crime and having certain information and he may be brought on record. In support of his contention, he has placed reliance on edition reported in 2017 part 9 SCC page 340. He has also placed reliance on the edition of the full bench edition of the apex court in Jagdish Singh case. The citation could read citation Jagdish Singh reported again. It is reported. The learned counsel for petitioner has filed objections disputing the claim, and he has also placed reliance on the edition of 2020 part 2 SCC page 474 and contended that at the most the petitioner can be, the applicant can be permitted to assist the prosecution. Having heard the arguments and perusing the report, it is evident that petitioner is seeking his impediment. At the outset, there is no provision in CRPC seeking impediment. Further, he is seeking, he has moved application under section 302 part 2 of 302 supposed to but it is in respect of permission to conduct prosecution, and subclause 2 is attracted if under subclause 1 permission has been accorded to conduct the prosecution. In the instant case, the permission is not yet accorded to the petitioner, but still he is moving an application in section 302 subclause 2, which is itself is not maintainable. Next. However, during the course of the arguments, the learned counsel for applicant would submit that he may be permitted to contest the matter, though not coming on record, and he may be permitted to address his arguments. The learned counsel for petitioner in this context submits that he can be permitted to assist the prosecution. However, this matter has been settled by the full bench of the Honorable Apex Court in edition Jagdish Singh referred Sutra, that the petitioner, the injured, the victim has got every right to make his submission. Admittedly, in the instant case, the applicant victim is not only informant, but he is the victim of the crime and he falls under the category of aggrieved person. Under these circumstances, considering the fact any of the decision laid down in Jagdish Singh, the petition, the applicant, he can be permitted to assist the, not only assist the prosecution, but also to advance the arguments, but at any cost, he cannot be brought on record as respondent number 2. Hence, the IA requires to be dismissed with IA does not survive for consideration, but his prayer can be molded by giving him an opportunity to contest the matter by opposing the bail petition filed by the petitioner by advancing arguments. Yes, accordingly, I stand for this program.
This is a clear bail application. Because the case of the complaint is lodged after a delay of 6 months. Delay has not been extended. This is a case of the prosecution that was 26/2/2022. The complainant had booked a ticket from Mysuru to Mangaluru, a Rajahamsa ticket. And to board the Mysuru bus, he was waiting at Mandya bus stop opposite the bus at 8 o'clock. At that point of time, the accused number 1, along with the other accused, have come, stopped their car near him, and have requested, I have spoken to them, and the complainant having acquaintance with the accused has boarded the car and has traveled together at 8 o'clock on 26/2/2022 to Mysore. And when it is a case again, it is a case that when they were supposed to reach Mysore, the other accused number 1 and 3, and other accused, I have requested, since the complainant is a gold merchant, is into gold business, accused have requested the complainant that some of his friends have brought gold biscuits and they were residing in a hotel called Darshan Paradise. Initially, it is again the case. Initially, the complainant has denied, but on request of the accused, he has gone to the place. When he has visited the spot near the room, as soon as he entered, a 20 to 25 years aged woman entered the room. Immediately, the other accused who were along with the complainant have locked the door, taken the videos, and have threatened her of dire consequences and have demanded 4 crore rupees. This is the case of the of the complainant. And subsequently, on 26/2/2022, at about 2 o'clock, after all the negotiations, they came to a settlement that 50 lakhs would be paid. Accordingly, 23 lakhs was collected from one of his friends named Shamit Shetty, 25 lakhs from another jewelry shop where the accused have gone and collected the money, and 2 lakhs another jewelry shop. The 2 lakh rupees has been collected. Altogether, 50 lakhs rupees has been collected. Subsequently, they have released the complainant. This is the case of the complainant. And in the complaint, the complainant also tells he has voluntarily boarded the car on having acquaintance with the accused. And further, it is the case that during the course of traveling, they have all introduced each other. But my lords, in the FIR, the name of the petitioner is not disclosed. He narrates in the complaint that they have introduced each other, but the name of the accused, the petitioner, is not disclosed. My lords, there is a delay of 6 months. There is no any explanation as to why the complainant was not in a position to go and lodge a complaint. Only in one para, he alleges that there was a threat. But surprisingly, the complainant is a political leader. He represents one of the political party. He enjoys all the muscle power. He enjoys all the financial. He is a gold merchant having a multi-storage store, a gold store. He enjoys all the power. But states there is a threat. What sort of threat? Whether the threat is existing, that has not been explained. Well, it's coming to the jurisdiction. The entire attack took place in Mysore, in the lodge called Darshan Palace. The money which has been collected is at Mysore. Where he was relieved is in Mysore. But the complaint is lodged in Mandya after 6 months. Why, my lords? Because he is an influential person in Mandya. He represents a political party. He has that muscle power. Using his muscular fat, he has having colluded with the respondent police, such a complaint has been lodged. So it is a well-drafted, orchestrated complaint. The entire investigation rests only on the statement of the complaint. There is nothing else rather than the complaint. Whatever the complainant narrates in the complaint, all the statements during the pendency of this case, the charge sheet has been done along with the memo. The entire case rests solely on the statement and the narration of the complainant. Because there is no one documentary evidence to showcase that the incident happened on 26/2/2022. Well, intentionally, after the lapse of 6 months, the complaint has been lodged. They are well aware. There won't be any evidence to disprove my story. There is no one, the entire charge sheet, I have gone through the entire charge sheet. There is no one documentary evidence to establish my story, to establish the story of the complaint, that the incident took place on 26/2/2022. The entire investigation rests on the statement of the complainant and the statement of 161 statements. Well, recently I'd been to a station in Bangalore. There, two ladies came there to register a complaint for missing person. The first thing the police inquired, they'll be missing in MG Road. Now though they claimed that they're residing in Bangalore, though the offense was missing, a person is missing for last 24 hours. Malak, this is out of this case. They didn't show any interest to lodge a complaint. This is the present affair of the state. This case,
That cannot be, you cannot brand all police officers in the same.
Very good. Very good.
There are say
This
honest,
was under the
sincere, prompt officers are also there, but majority may be in another way. But the fact is remains, you are harping on the complaint is being lodged in Mandya. The fact remains that the alleged incident has started from Mandya when he boarded the car.
As per your state,
Whether he was voluntarily boarded or he was persuaded, the commencement is from Mandya. It is a continuing an offense. All the concerned police jurisdiction police stations will be having jurisdiction. Otherwise, you could have challenged it immediately. Huh? You could have got it passed. Sorry.
Leaving that there is no any documentary proof to establish the occurrence of the incident. The complainant claims that 25 lakhs has been collected from his known person, 23 lakhs. Their statements have not been recorded. How they got money? How 25 lakhs liquid fund was ready? You call my ಹೇಳಿದ ತಕ್ಷಣ 25 ಲಕ್ಷ ಎತ್ಕೊಡಕ್ಕೆ ಅವರ ಹತ್ರ liquid cash. Within, as per the complaint, everything happens in a spontaneous 1 or 2 hours. Their source of money. This has not been investigated. The police doesn't make any attempt to unfurl the events. They just, based on the complaint story, narration, they proceed to close their investigation. But, this is a case where the complainant was caught red-handed, assaulting a woman. And the conversation, the phone conversation between the complainant and the victim and the video was made viral throughout the state. For more than a week, it was telecasted in all the video, all the channels, press media. The police have not made an attempt to take the video or the phone conversation. They have not produced any of, they have not investigated into the material thing which had to be investigated. Just based on the story. This is a false complaint, a complete false story, which has been lodged by the complainant to save his skin. He has a future, he has future plans of contesting elections. In the fear of his future and political career would be pampered, such a false narration or story has been lodged. And based on that, I am a victim. I have been trapped into this case. The only recovery, a cash of 88,000 rupees has been recovered from me. ನನ್ನ ಮನೆಗೆ ಬಂದ್ರು 50,000 1 ಲಕ್ಷ ಸಿಗುತ್ತೆ. Only because money has been recovered from a person, it doesn't mean he has participated in the incident. The CDR reports. The vital thing which would have unfurled the events is the video which was circulated in the press media. Why weren't those collected? Why didn't the investigating officers investigate into that matter? Who circulated it? Why was it circulated? Whether the contents were genuine or not. FSL reports, nothing is there. This is a tainted investigation and a poached up investigation. Based on such material irregular investigation, I cannot be kept under prison. My rights cannot be taken away in such an arbitrary fashion. Is what my request. I have been arrested on 21/9/2022. Till date, I am under prison. All my rights have been. But accused number 1 has been released. All the allegations against all the accused is very similar. It is just cut and paste. There is no any extra allegations against one accused and another accused. Accused 1 has been released on bail by the Honorable Session Court. Accused number 7, I am accused number 6. Accused number 7 has been enlarged on anticipatory bail. That being the case, my lords, I humbly pray that any stringent condition may be imposed on me. I would support the investigation. I have a prima facie case. I will establish my innocence. I may be enlarged on regular bail. It's my humble thing.
Yes, sir. Yes, it's. So in fact, in how many days if 50 lakhs was collected? So go through the records and submit. Within how many days or how many hours the amount was paid?
26, sorry to interrupt, since only it is a wrong fact that I am into anything. 26, 8 o'clock, he was boarded the car. 2 o'clock, 27, 2 a.m., the negotiation took place as per the complaint. Morning, 10:30, 27/10/2020, 27/2/2022, money was, the entire money was collected.
Yes. It is expected in the complaint. It's like a continuous finding out. Yes. Because without manners, how I will not go to recovery. I'll go to collection of the amount. How the amount was paid. How the amount is paid. Simple question. Your case is that it is a ransom by way of cash. Source of amount, any inquiry? It is not a small amount of 50,000, 1 lakh. 50 lakhs has been paid as a ransom. In that event, it should be a declared amount. And his main argument is that the person who we are alleged to have been paid the ransom on behalf of the complainant, their statement is not recorded by the IO. Then how you are going to prove the payments? See, I am simply asking you certain questions, sir. I'm not asking you source of income. I'm asking you according to him, I do not know. As per his contention, he submits that the amount was paid in 3 installments, 23 lakhs, 25 lakhs, and 2 lakhs by 3 persons on behalf of the complainant on the very next date. Correct? You admit it. Have you recorded the statement of those persons who have paid that amount? Because according to him, statement of the said persons itself is not recorded. Let's have it. That statement disclosed 25 lakhs. And one Arjun Lal, you are making false submission then. You have made false submission. So, see, when we trust it, it should be fair, you know.
The statements are not statement and the cash and collect.
That, you would have argued in that way, but your contention is that statement itself is not recorded. But that way your statement appears to be very false on the records itself. Yes. Right. 250 lakhs is paid. How they have mobilized that amount, where they have shown, from where they have shown the amount. He is not a jeweler. 25 lakhs is paid by one Srinivas Shetty according to you. He is a LIC officer. How he mobilized 25 lakhs cash? Did you investigate? Ishte kelidde nanu. Whether he withdrew it from the bank or he was possessing that hard cash in his house. Where you have shown that amount. He is a development officer in LIC and immediately mobilizes hard cash of 25 lakhs.
ನನ್ನ ಮೊಬೈಲ್ಗೆ ಕರೆ ಮಾಡಿ ಈಗ ಮೈಸೂರಿನಲ್ಲಿದ್ದೇನೆ ನನಗೆ ಹಣ ಬೇಕು ಭೇಟಿ ಮಾಡಿ ನಾನು ಅವರಿಗೆ
ಆಯ್ತು. So according to you, he went to Mandya and from one Rajeshri jewelers, he recorded, received that 25 lakhs. Have you recorded the statement of that owner of the Rajeshri jewelers? Have you checked their bank statement? $25 ಲಕ್ಷ ಪಾರ್ಟಿಗೆ ದುಡ್ಡು ಬೇಕು ಅಂತ ಹೇಳಿ ಇಸ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ದೀರಿ. That amount is required for party fund. ಸರಿ ಹೇಳಿ, ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ನೋಡೋಣಂತೆ. ಜ್ಯುವೆಲರ್ ಇದ್ದವ್ರೆಲ್ಲ 25 ಲಕ್ಷ ರೂಪಾಯಿ ಹಂಗ ಹೋಗಿ ಬರೋರು ಕೊಡಕ್ ಆಗಲ್ಲ. They will have to maintain an account. ಕ್ಯಾಶ್ ಇಟ್ಕೊಳ್ಳಿ ಸರ್. ಕ್ಯಾಶ್ ಹೊರಗೆ ಹೋಯ್ತಂದ್ರೆ ದೇರ್ ಶುಡ್ ಬಿ ಕರೆಸ್ಪಾಂಡಿಂಗ್ ಎಂಟ್ರಿ. ಅದನ್ನ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು. ಕ್ಯಾಶ್ ಇಟ್ಕೊಳ್ಳೋದಕ್ಕೆ ತಪ್ಪಂತ ಹೇಳಲ್ಲ. Cash it, jewelers close together, they maintain the cash. There is no issue about it. But when the cash is paid to somebody, that amount is required to be shown, alva. where it was shown. He should have submitted the income tax returns by this time. Income tax returns ಒಳಗೆ 25 ಲಕ್ಷ ಬಗ್ಗೆ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಕೊಡ್ಲೇಬೇಕು ಅವನು. Otherwise it is a black money ಆಗುತ್ತೆ. Hand loan ಇಲ್ಲಿ 20 ಲಕ್ಷ 25 ಲಕ್ಷ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ತೋರ್ಸಕ್ಕಾಗಲ್ವಾ? ತೋರ್ಸ್ಲೇಬೇಕಲ್ವಾ? Because the 20 February the incident has taken place. The financial year is closed. The returns ought to have been submitted. They are bound to be submitted. ತೋರ್ಸ್ಲಿಕ್ಕೆ ಬೇಕಲ್ಲ, because they have not yet received back that amount. Forget about 2 lakhs. That is small amount. Anybody can 2 lakhs becomes common. Adar ಬಗ್ಗೆ raise ಮಾಡಲ್ಲ. But major amount ಬಗ್ಗೆ ನಾನು ಕೇಳೋದು. He has misled the court. I don't dispute it. He has misled the court. Then how you are going to explain how that how he may be having that amount, but when he has paid it, it should be reflected in some records. It cannot be an unaccounted amount. It should be accounted. It should be an accounted amount, alva. ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮುಗಿದ್ಮ್ಯಾಗ ಈಗ ನಾನು ಕೋರ್ಟ್ ನ ಪ್ರಶ್ನೆ ಕೇಳಿದಾರ ಇನ್ನು ಹೊಸದಾಗಿ ಮತ್ತೆ ABC ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳ್ತೀರಲ್ಲ ನೀವು. ಸರಿ ಹೇಳಿ ನಿಮ್ದು, ಅವರು ಏನ್ ಹೇಳ್ತಾರ ವಿಚಾರ ಮಾಡೋಣ. Yes.
But from the position of distribution of the lots,
88,000 recovered according to his own submission. ₹88,000 ಎಲ್ಲರ ಕೈಗೆ ಸಿಗುತ್ತಲ್ರಿ. 88,000 ಈಗ ಮೇಂಟೈನ್ ಮಾಡೋದು ಕಷ್ಟನ. ಎಂತೆಂತರ ಕೈಯಾಗಿರುತ್ತೆ ಮನೆಯಲ್ಲಿ. ಹೆಣ್ಮಕ್ಳ ಕಡೆ ಹೋದ್ರೆ ಡಿಮಾನಿಟೈಸೇಷನ್ ಹೋದ್ರೆ 2 ಲಕ್ಷ ಹೆಣ್ಮಕ್ಳಿಗೆ ಎಕ್ಸಾಮ್ಷನ್ ಕೊಟ್ಟಿದ್ರು. Housewives, no questions should be posed because ಅಷ್ಟು ಮನಿ ವ್ಯಾಲ್ಯೂ ಇದೆ. ಅಲ್ಲ ನಾ ಅದ್ರ ಬಗ್ಗೆ ಹೇಳಿಲ್ಲ. 88 ಸೀಸ್ ಮಾಡಿದ್ದು ಅದನ್ನ ಎಕ್ಸ್ಪ್ಲೇಷನ್ ಕೊಟ್ಟು 88 is not a big amount to give an explanation. ಅದನ್ನ ಹೇಳಿದ್ ನಾನು ಅಷ್ಟೇ. Who says that he never raised an issue that amount doesn't belongs to him? You are arguing now. You are presuming the things. It was recovered at his instance. He has got every right to reclaim that amount. Matter is not closed. Matter is still at the stage of the trial, sir. You cannot say that he is not recovering the reclaiming the amount. You cannot presume, and you cannot assess his defense at this juncture. ಸರಿ ಹೇಳಿ. Yes. Now you can assist the court.
The organized crime, the submission reports on these, my lord, accused are, my lord, associates each other, very professionals and white collar organized offense every time. It's not first time in Mandya district. They are, my lord, very well doing their.
I'll make it very clear first. Before using any defamatory words, you think twice. I will caution you, that's all. Don't argue as if the crime is proved.
normally I'm always accused. I know it.
So that on you don't argue as in case of an accused, because now responsibility will be more on you. You tend to move on the accused side.
First submission is organizing time. Second submission is, my lord, all accused, my lord, know each other to do, my lord, this offense. Then, my lord, according to the prosecution themselves, it is not a first time, my lord, the accused number one, under the her instance, instruction, my lord, the things has been repeatedly done. Then, my lord, my humble submission before this honorable court, the amount which has been arranged, that is, my lord, crucial question which has been asked. The amount is which has been arranged, my lord, is, my lord, all the owners of the jewelry shop. Of course, my lord, sometime, my lord, every time we cannot expect, my lord, to maintain, my lord, or prior permission. I'm giving so much of amount to so and so person, because he is having a, my lord, 32 years of rich gold jewelry business in the city of the Mandya. And my
I'm
lord,
not talking about those aspects. I'm simply asking one simple question. When the amount is paid by a particular person,
yes,
when it is not returned,
yes,
he should show it in account statement while declaring his income tax. His plus and minus statement also. His account, it should deflect, pay to somebody else. Whatever it may be.
first off,
If it is refund within the period of submission of the income tax return, that may be exempted. But it is not returned as per the case of the prosecution.
first of all, this money is, my lord, used for purpose of, which is not in the legal issues. He is already under the threat of, my lord, life.
What I'm not asking,
That's
my
what
say,
my
if it is not a legal amount,
no, the money which is used for not legally, for not legal purpose, because he
that
has
is-
to pay.
see, whatever it may be, where money is used for legally or otherwise, that is a secondary. Some money is the person who has paid it doesn't say, because the persons who paid it may not be knowing for what purpose. And they were not made except CW19. Except CW19. What is done? They were asked to pay to this person, they paid it. Matter ends there. Whether it is illegal payment, they were not aware. So they debited that amount in your name. Simple things. They debited the amount in your name. Then it should be reflected in all the account statement that some amount is paid to you.
Lord, every time we cannot expect, Lord, to maintain such a document. The prosecutor knows well, ever, my lord, how the Karnataka money has shifted to Delhi. Only, my lord, one
Nanu gottilla, sir. Don't involve the court.
because I am on the.
Don't involve the court. You may be knowing it.
My lord, QR code as my lord mentioned, how much floor has shifted. This, my lord, we are with my lord in the.
You might be having knowledge, but I don't have.
So, my lord, the number of the figure of the bank of my lord, sometimes, my lord, it is not mentioned or compulsory to maintain in the account. Some QR code, my lord, they are mentioning, my lord. That is what, my lord, it is not necessary or not compelled to mention in their account.
It is mandatory under income tax rules, sir.
Of course.
Then
Even, my lord,
you can, even if you mention in QR code, you will have to give explanation. What is that QR code?
ನನ್ನ ಫ್ರೆಂಡ್ ಸಪೋಸ್ ಈ ಆಸ್ಕ್ ನನ್ನ ಮೊಬೈಲ್ ಕಳೆದೋಯ್ತು ಓನರ್ 10,000 ಕೊಡಿ ಅಂತ ಹೇಳಿ ನಾನು ಕ್ಯಾಶ್ ಕೊಟ್ಟಂಗಿಲ್ಲ ಆಫೀಸ್ ದಟ್ ಈಸ್ ದಿ ಮೈ ಲಾರ್ಡ್ ಟುಡೇಸ್ ದಿ ಪೊಸಿಷನ್ ಆಫ್ ದಿ ಲಾ so that my lord we cannot expect and compel everyone to my lord maintain their account with respect to the transaction. Sometimes for where the purpose for this maybe my lord it has lapsed. Then my lord,
then according to you all this money is otherwise generated to meet the various otherwise expenses. I do not know the way you are arguing.
The Lord's worship is then, my Lord, my humble submission before this honorable court. Conduct of the accused to my Lord. Conduct of the accused to my Lord is, my Lord, they are very much involved with the subject matter. Otherwise, my Lord, no person will, no prudent person will go to the, my Lord, yes, unnecessarily indulge with such kind of crime. Why not it is only for the, my Lord, Harish? Why not it is for Ganesh? Because, my Lord, he has, my Lord, actively participated in the crime. So that, my Lord, my humble assistance before this honorable court, my Lord. My Lord, if already, my Lord, complainant, already one person is released, my Lord, already threat he has received, he has not one more complaint. Accordingly, NCR also registered. So that, my Lord, my humble submission before this honorable court, my Lord.
Then why you are not moved for cancellation of the bill against ಸರ್ಕಾರಕ್ಕೆ ಅದಕ್ಕೆ ಸರ್ಕಾರಕ್ಕೆ ನೀವೇ ಮಾಡ್ಬೇಕು ಇಲ್ಲಿ ಬಂದು ಇಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಇಲ್ಲಿ ಪಾರ್ಟಿ ಆಗಿದ್ರಿ ಯು ಹ್ಯಾವ್ ಗಾಟ್ ಎವ್ರಿ ರೈಟ್ ಟು ಸಿ ಕ್ಯಾನ್ಸಲೇಷನ್ ಆಫ್ ದಿ ಬಿಲ್.
These people are too mature to say. That is what, my Lord, my humble submission before this honorable court. He has not, my Lord, after filing the charge sheet, he has not approached the learned trial court. During the pendency of the, my Lord, this petition, the charge sheet was filed. When, my Lord, this bail petition came to be a agreed petition, my Lord, that judgment, during that time, my Lord, no charge sheet was filed. When after, my Lord, when pending before this honorable court, in the meantime, charge sheet filed.
Is there any bar?
No, absolutely no. Even he can directly approach this honorable.
Directly approach madak baralla because there are a lot of settled law.
Variation. Yes. So that, my Lord, mainly reject, my Lord, the bail. Sorry for that.
Sorry, agree. Huh? Yes, anything you want to add?
Yeah, unconditional apology. Oversight. That has been, what I wanted to mean was only that the statements and the accounts has not been investigated, not been produced in the charge. Even with respect. Well, there is no any cases pending on him against.
Yes.
For the first time, he's been arraigned as an accused in this sort of offense.
In ಮುಂದೆ ಬರ್ತಾ the way he is submitting, be prepared for facing other person.
Even if I'm released on bail, I anticipate one more 323 offense on.
Heard. Reserved. I will not carry it, but we trust what I mean. We trust you. New statement, we will accept it as a ಅಷ್ಟೇ. What is this? Have you served the copy on the other side? ಎಸ್ ಹೇಳಿ.
After the death of the father, they changed it to the Tata to the name. They don't change that. The authentication, they are not doing that. Our documents.
Yes. Yes, what you have to say? Your allegation is that only 60% of the sites were released and only 62 sites have been formed. And according to your allegation, the area reserved for the park was subsequently converted into sites. And for that purpose, you should notice your allegation is that no documents have been produced. Now, what you have to say? Are you disputing this approved plan by the town planning authority? This disclose that 61, 62, 63, 64, 66 sites have been formed. And they are not part of the garden area or park. So now, therefore, I am asking you, your allegation made in the complaint is that documents were not produced when you are called upon. So you have prosecuted that on fabricated documents they have sold. Now he has produced the Xerox copy of the town planning plan, approved plan. Then you will have to say, if you say that this is also forged, he will be prosecuted by the court himself. Court will lodge a complaint for having for having produced a forged document before the court in a judicial proceedings. Court will become a complainant. But he is producing original. Can you say that it is a forged document? It is a very serious issue. If this is the case, why you have not approached the other forum under 482? ಅಲ್ರಿ ಮೂರ್ನಾಲ್ಕು ತಿಂಗಳ ಆಯ್ತಲ್ಲ ಇಲ್ಲಿವರೆಗೆ ನಿಮ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಇದನ್ನ ಡಾಕ್ಯುಮೆಂಟ್ ಹೆಸರು ಮಾಡಿದ್ರೆ ಅವ್ರು ಕ್ವಾಶ್ ಮಾಡ್ತಿದ್ರು. ಏನ್ರಿ ನಿಮ್ ದುಡ್ಡು ಬೇಕು, ಟ್ಯಾಕ್ಸು ಬೇಕು, ಸ್ವಲ್ಪ ಅಸೆಟ್ ಜನರಲ್ ಅಂಡ್ ಹಿ ಇಸ್ ಪ್ರೊಡ್ಯೂಸಿಂಗ್ ದಿ ಒರಿಜಿನಲ್ ಆಲ್ಸೋ. ಅಸರ್ಟೈನ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಮಂಡೇ ನಿಮ್ದು ಇದೇ ಸ್ವಾರಿ ಆಯ್ತು. ಕೋರ್ಟ್ ಹಾಲ್ ಒಳಗೆ ಮೂವ್ ಮಾಡೋದು, ಸ್ಟೆಪ್ಸ್ ತಗೊಳಂಗಿಲ್ಲ. ಬೆಸ್ಟ್ ವೇ ಇಸ್ ಟು ಡಿಸ್ಮಿಸ್ ದಿ ಪೆಟಿಷನ್. ಏನ್ರಿ ಸಾರಿ, ಕೋರ್ಟ್ ಹಾಲ್ ಮೂವ್ ಮಾಡ್ತೀರಿ, ಪಿ ಎಫ್ ಕೊಡೋಂಗಿಲ್ಲ. ಬೆಳಿಗ್ಗೆ ಬಂದು ಇವತ್ತು ಕೊಟ್ಟಿದ್ದೀನಿ ಆಫೀಸ್ದಲ್ಲಿ ಅಂತ ಹೇಳೋದು. ಏನು ಓವರ್ಸೈಟ್ ರೀ, ಸೀರಿಯಸ್ನೆಸ್ ಇಲ್ವಾ ನಿಮಗೆ? The Learned Council for Petitioners submit that the needful has been done in the office to verify and proceed to issue notice to R to release the matter after 2 weeks. Uh, 59 ವರೆಗೆ ಸಿಕ್ಕಿದೆ, 59. What Monday or Tuesday? Request Tuesday. Two weeks. Shall I grant it 4 weeks? Oh, sir. Take 2 weeks. ನಾನು ನೀವೇ ಫೈಲ್ ಮಾಡ್ತೀರೋ ಬಿಡ್ತೀನಿ, ನಿಮಗೆ ಬಿಟ್ಟಿದ್ದು, ನನಗೆ ಸಂಬಂಧ ಇಲ್ಲ. Yesterday matter ಅಲ್ಲ ಇದು, ಏನಿದೆ? ಅಲ್ಲ, ಏನೋ ಒಂದು ಇಶ್ಯೂ ಇವತ್ತು ಕ್ಲಿಯರ್ ಮಾಡ್ತೀನಿ, ಏನೋ ವೆರಿಫೈ ಮಾಡಿ ಹೇಳ್ತೀನಿ, ವಿಲ್ ಕಮ್ ಬ್ಯಾಕ್ ಟು ಇವತ್ತು ಬರ್ತೀನಿ ಅಂತ ಇನ್ನು ನೀವು ಏನು ಹೇಳಿದ್ರಿ? The 2 persons in the same name. The complainant and accused number 1 and 2 are accused number 1 and are one and the same. And you wanted to submit whether the writ petition filed by accused number 1 is not a genuine, order is also forged ಅಂತ ಹೇಳಿ ಡಿಫೆನ್ಸ್ ತಗೊಂಡಿದ್ರಿ, ನೀನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರಿ. If I am correct, that was as per your information provided to you, that the order of the writ petition is also fabricated ಅಂತ ಹೇಳಿ.
Will not the owner of the land.
ನಾ ಅದಕ್ಕೆ ಕೇಳಿದ್ದು, yesterday only I have asked you if that is the case. It was happened in 2017, 14, 15 and 17. For 5 years, no steps were taken to recall that order of the writ petition. A person impersonated the High Court. Have you moved the court to initiation action against that person? For ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ, very fraud on the court. In that event, he should have moved the court to initiate action against that person, to lodge a complaint. Court will become a complainant.
This petition that has been filed, they are relying upon this affair. There is a lot of notice that counting of all the
506, 384. Yes.
Based on that, the order of the High Court which rejected it is dated 20th of October 22. Which is at page 19. Date of the order, refused to grant it. Is 20th of October. However, on 2/10/22, an application to include 465, 458, 471, 450, 34 IPC had been filed. And on 3/10/22 came here, This application has gone on the basis that the only provision should not work.
No, that is a different aspect because FIR may be quoting simple provision, but subsequent event will have to be considered. The IO might have sought for inclusion of certain sections, deletion of certain sections, inclusion of some other accused. That is.
Also, the time did not have the opportunity to examine it from so that. It has gone only on the basis of 5 months.
But there is no records on the before the court.
Either producing it wrong. Application and the order of it.
Sir, you are not included 419. And 418 is cheating, trust cheating. That is not an issue. Before whom the trust is. But your allegation is regarding impersonation. He because in the name of original complainant, he himself impersonated as that of a original claimant. Let it be further. But the basic offense is impersonation. That itself is not included.
That's true. But what has happened, to that effect, if we moving this court for action to them when these provisions are already affected, the only sufficient action measure would be that possibly with these provisions, he has to approach the. But the board, they are still to outside.
Yes, what you have to say?
Oh, that's what I trying to do the date, sir. Exactly because of that I told the date.
He said that on 2/10/22, this application is moved and permission was accorded on 3/10.
On the date,
As of the date, the prosecution.
That was not even,
Could have brought to the prosecution, could have brought to the.
neither the prosecution has brought nor the petitioner has brought, nobody has brought it. And it was not a. One minute. Because the proceedings were not taken before the same court. The proceedings were before ACMM. The bail was tried by the city civil court. So court had no occasion unless it was brought to the notice.
Please, let it alone.
by non-parents are making a submission, but this let him take a second note.
But for your lapses, why you should?
But back remains the same.
That is correct, but it is your lapse, isn't it?
The fact remains that the court did have.
Well, court are, but when you are not allowed the court to consider it. So let us continue it. There is no issue. But the fact remains as it is, since you are making serious allegations. Now, on record, he has got certain documents in the form of writ petitions and other things. Impersonation and other things. Impersonation, no allegations made. No offense is incorporated. Though all along it is the one main allegation is that he has been impersonated in the name of original complainant by using a similarity in the name.
All attributed to this accused is all creation and fabrication of all documents.
See, that is one aspect. See, false benefit for as against even at least 419 should have been there. And all along it is even who regularly approach the by way of writ since 2013.
That this is a grave economic offense. Their public money has been utilized. Falsification is taking place. Investigation is going on. 438, but this accused is not available. That would be
No,
my
no.
submission.
No. You can also go through it. Go through it.
Yeah, the signature number one is an advocate who represented, who appeared before the KIDB in filing complaint.
Hello, I am not expressing regarding the
Money is not withdrawn. Money is not. Money may not, there is a inquiry, the proceedings are pending before the KIDB, and there is a direction by this honorable court in the writ petition. The KIDB shall proceed and pass an order and refer the matter to the civil court. And so the civil court will have to adjudicate who is the original owner, who is the person.
So now the issue is establishment of identity of the real person,
Yes,
whether
yes.
it is the complainant or accused number one. Ultimately, it stands there.
But that is not the concerned person.
Then things are entirely different. If he is not a original owner or otherwise, things are entirely different. But the question will be again, an advocate only on the basis of identification, whether he can be found equally responsible is also a question to be considered. That is also
Legal doubt may not be the advocate should not identify, produce documents on behalf of the parties.
Exactly, adne ಹೇಳ್ತಾ ಇದೀನಿ ಅವ್ರಿಗೆ. Merely because only except identification,
Yes.
except identification, no further steps were taken, things would have been different. But if an additional interest is shown or additional involvement is this shown, things may change. That is.
When a party to the proceedings or something else, they cross the brief.
ಯಾವಾಗ ನೋಡಿ ಹೇಳ್ತೀರಿ? Tuesday. 8th ಆಗ್ಬೋದಾ? ಆಯ್ತು 8th. Rest of the matters. The office discloses that the office objections have been complied with. Hence, issue notice. The learned HCGP is directed to take notice for respondent state and file objections if any. Is the matter after 2.
Number 16. Ramshankar TP.
This matter have been informed by the trial court that they are not filed other hand, my lords, the petition is a crime offender. The ruling of the Supreme. They are not entitled for the top.
ಅದಕ್ಕೆ ಪ್ರೊಕ್ಲೇಮ್ಡ್ ಅಫೆಂಡರ್ ಇದ್ದಾಗ ಬರೋಲ್ಲ ಒಂದೇದ್ದು. ಎರಡನೇದು, the second thing, you should first exhaust your remedy before the concerned trial court, the sessions court. In both way it is hit. Then what?
I would make the I would surrender the petition before the trial court, and I will make a petition in the section court of the. I need direction may kindly be given to dispose of within time.
Within time, I'll do it. The learned counsel for petitioning submit that he is prepared to surrender before the jurisdictional court, and he is going to move application for regular bail he requests that the time frame may be fixed for disposal of the said bail petition. In case it is being filed, the submission is placed on record. In view of the said submission, petition is dismissed as withdrawn. Next, in case petitioner surrenders and moves a regular bail application, the concerned trial court is hereby directed to dispose of the same as expeditiously as possible. Time frame hang hakak barolla because the Supreme Court has already fixed the time frame. In case of 439, 7 days. In case of 438, 14 days. That time frame is fixed by the Supreme Court. Then question of non fix madak barolla adike nan what use madidini. That is expeditiously means it clearly clarifies it. Nim 16 alla nimdu. ಮಾಡಿದಾರ already filed memorandum appearance. Memo of appearance for respondent. Use the matter after 1 week for objections. ಅರ್ಜೆಂಟ್ ಮಾಡೋಣ ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ ನಾನು ಒಂದೊಂದು ಬರ್ತೀನಿ 1 by 1 I'll come. 62 ನಾಳೆ ನಾನು ಇರಲ್ಲ ನೀವ್ ಯಾರ ಮುಂದೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀನಿ ಅಂದ್ರೆ ನಂದೇನು ತಕರಾರು ಇಲ್ಲ. ಐ ಆಮ್ ನಾಟ್ ಸಿಟ್ಟಿಂಗ್ ಅಷ್ಟೇ ಅದೇ ಹೇಳ್ತಾರೆ. ಮಂಡೇ ರೀಚ್ ಆಗ್ಲಿಕ್ಕಿಲ್ಲ ಮಂಗಳವಾರ ಹಾಕಿ ಟ್ಯೂಸ್ಡೇ 62 ಮಂಡೇ ರೀಚ್ ಆಗೋದು ಕಷ್ಟ. ಈ ಒಂದೆರಡು ಮ್ಯಾಟ್ರ್ ಈ ರೀತಿ ಬಂದ್ರೆ ನಾನೇನ್ ಮಾಡ್ಲಿ? ಈ ಚಾನ್ಸ್ ತಗೊಳಿದ್ರೆ ನಂದೇನ್ ತಕರಾರು ಇಲ್ಲ, ಬಟ್ ಪ್ರಯಾರಿಟಿ ಏನು ಬರಲ್ಲ. ಮಂಡೇ ಮಂಡೇ ಏನಾಗಲ್ಲ. ವೆನ್ಸ್ಡೇ ಕೊಟ್ಟಿರ್ತೀನಿ. ವೆನ್ಸ್ಡೇ 7th ಇದ್ರು ನನ್ನ ಹೆಸರು ನಾನು ಬರ್ಡನ್ ಮಾಡ್ಕೊಂಡ್ರು ಪರ್ಪಸ್ ರೀಚ್ ಆಗೋದಿಲ್ಲ. ವೆನ್ಸ್ಡೇ ಹಾಕ್ತೀನಿ ನಾನು. ನಾರ್ಮಲಿ ಐ ಆಮ್ ಗಿವಿಂಗ್ ಡೇಟ್ಸ್ ವಿಚ್ ಐ ಕುಡ್ ರೀಚ್. ಅನ್ನೆಸರಿ ಎಲ್ಲ ಒಂದ್ ದಿವ್ಸ 100 ಲಿಸ್ಟ್ ಮಾಡಿ ಪರ್ಪಸ್ ಸರ್ವ್ ಆಗೋದಿಲ್ಲ, ಎಲ್ಲ ಹೋಗುತ್ತೆ. ಸೊ ಯು ಟೇಕ್ ಇಟ್ ಆನ್ ವೆನ್ಸ್ಡೇ. No representation on behalf of petitioner list after 2 weeks. There is no representation list after 2 weeks. You are for petitioner. ಬನ್ನಿ ಸರ್, ನಿಮಗೂ ಸರ್ವ್ ಮಾಡ್ಬೇಕು. ಅವರು ಕೊಟ್ಟಿದ್ದಾರೆ. I1 of 22 is filed for impleading. Copy now it is submitted that copy is served on the learned counsel for petitioner as well as HCGP. Hence office objection stands complied.
Just for Tuesday.
Yeah, what is the offense?
This is 307 498A. Yes, for Tuesday, there are 2 other matters by accused number 2 and 3. This petition, I'll serve a copy. This petition is by accused number 1.
Yearly, but Tuesday it becomes a very difficult, sir. You take a better on Wednesday.
The advocate has something.
ಇಲ್ಲ 8th ತಗೊಳ್ಳಿ, Thursday ತಗೊಳ್ಳಿ. Tuesday already a number of post ಮಾಡಿದ್ದೀನಿ and I am giving preference to 439. ನಿಮ್ದು 438 ಒಳಗದ್ರಿ ನೀವು.
Possible you could take a chance
No.
on Tuesday.
See, I don't want to get myself burdened. ಎದ್ದೋದ ಕೂಡ್ತೀನಿ ಸಾಯಂಕಾಲ 6 ಗಂಟೆ ಕೂದ್ ಪರ್ಪಸ್ ಆಗೋದಿಲ್ಲ. ನಿಮ್ ಏನ್ ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದ್ನಿ ಅಂದ್ರ ರಿಲೀಸ್ ಆಗ್ಬೇಕು, ಕರೆಕ್ಷನ್ ಆಗ್ಬೇಕು. ಅವಾಗೇನ್ ಚೇಂಬರ್ದಲ್ಲಿ 1.5 ಗಂಟೆ ಅದೇ ಇರ್ತದೆ ಅಂತ ಅನ್ಸುತ್ತೆ.
Very well. Then
You can understand the ಯಾಕಂದ್ರೆ ನಿಮಗೆ ರಿಲೀಸ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಪರ್ಪಸ್ ಆಗೋದಿಲ್ಲ. When you get a order, you should get the copy of that order instantly. That is the intention. ಹೌದಾ? ಈಗ ನೀವು ಒಂದು ಆರ್ಡರ್ ಮಾಡಿ 8-10 ದಿನದವರೆಗೆ ಕರೆಕ್ಷನ್ ಅಂತ ಇಟ್ಕೊಂಡ್ ಬಿಟ್ರೆ ಏನ್ ಪರ್ಪಸ್ ಸರ್ವಾಯ್ತು? ಇಂಡೈರೆಕ್ಟ್ಲಿ ಡಿನೈಂಗ್, ಕೊಟ್ಟ ಡಿನೈ ಮಾಡಿದಂಗ ಆಗ್ಬಾರ್ದು. ಟ್ಯೂಸ್ಡೇ, ವೆನ್ಸ್ಡೇ, ಥರ್ಸ್ಡೇ
other matters to be connected.
ಅವತ್ತು ಅದನ್ನ ಹೇಳ್ಬಿಡಿ. ಇದ್ರೊಳಗೆ ನಾನು ಹೇಳಕ್ ಬರ್ದಲ್ಲ. ಇದ್ಯಾರ ಡೇಟ್ ಗಿವನ್ ಇತ್ತಂದ್ರೆ ಅವತ್ತು ಬರ್ತಾವ. ಡೇಟ್ ಈಸ್ ನಾಟ್ ಗಿವನ್, ಹಂಗಿರ ಕೊಡಿ ಅಂತ ತಗೊಳ್ಳಿ. Is this matter 70 ಒಳಗೆ list this matter on 8 along with so and so.